The Revised Penal Code of the Philippines. An act revising the Penal Code and other penal laws. Book 2. Crimes and Penalties. Title 1. Crimes Against National Security and the Law of Nations. Chapter 1. Crimes Against National Security. Section 1. Treason and Espionage. Article 114. Treason. Any person who, owing allegiance to the United States or the government of the Philippine Islands, not being a foreigner, levies war against them or adheres to their enemies, giving them aid or comfort within the Philippine Islands or elsewhere, shall be punished by reclusion temporal to death and shall pay a fine not to exceed 20,000 pesos. No person shall be convicted of treason unless on the testimony of 2 witnesses at least to the same overt act or on confession of the accused in open court. Likewise, an alien, residing in the Philippine Islands, who commits acts of treason as defined in paragraph 1 of this article shall be punished by prison to death and shall pay a fine not to exceed 20,000 pesos. As amended by Executive Order No. 44. May 31, 1945. Article 115. Conspiracy and proposal to commit treason, penalty. The conspiracy or proposal to commit the crime of treason shall be punished respectively by prison and a fine not exceeding 10,000 pesos, and prison correctional and a fine not exceeding 5,000 pesos. Article 116. Misprision of treason. Every person owing allegiance to the United States, the government of the Philippine Islands, without being a foreigner, and having knowledge of any conspiracy against them, conceals or does not disclose and make known the same, as soon as possible to the governor or fiscal of the province, or the mayor or fiscal of the city in which he resides, as the case may be, shall be punished as an accessory to the crime of treason. Article 117. Espionage. The penalty of prison correctional shall be inflicted upon any person who 1. Without authority therefore, enters a warship, fort, or naval or military establishment or reservation to obtain any information, plans, photographs, or other data of a confidential nature relative to the defense of the Philippine archipelago, or 2. Being in possession, by reason of the public office he holds, of the articles, data, or information referred to in the preceding paragraph, discloses their contents to a representative of a foreign nation. The penalty next higher in degree shall be imposed if the offender be a public officer or employee. Section 2. Provoking war and disloyalty in case of war. Article 118. Inciting to war or giving motives for reprisals. The penalty of reclusion temporal shall be imposed upon any public officer or employee, and that of prison upon any private individual, who, by unlawful or unauthorized acts provokes or gives occasion for a war involving or liable to involve the Philippine Islands or exposes Filipino citizens to reprisals on their persons or property. Article 119. Violation of neutrality. The penalty of prison correctional shall be inflicted upon anyone who, on the occasion of a war in which the government is not involved, violates any regulation issued by competent authority for the purpose of enforcing neutrality. Article 120. Correspondence with hostile country. Any person who in time of war, shall have correspondence with an enemy country or territory occupied by enemy troops shall be punished. 1. By prison correctional, if the correspondence has been prohibited by the government. 2. By prison if such correspondence be carried on in ciphers or conventional signs, and 3. By reclusion temporal, if notice or information be given thereby which might be useful to the enemy. If the offender intended to aid the enemy by giving such notice or information, he shall suffer the penalty of reclusion temporal to death. Article 121. Flight to enemy country. The penalty of arrest shall be inflicted upon any person who, owing allegiance to the government, attempts to flee or go to an enemy country when prohibited by competent authority. Section 3. Piracy and mutiny on the high seas. Article 122. Piracy and general and mutiny on the high seas. The penalty of reclusion temporal shall be inflicted upon any person who, on the high seas, shall attack or seize a vessel or, not being a member of its complement nor a passenger, shall seize the whole or part of the cargo of said vessel, its equipment, or personal belongings of its complement or passengers. The same penalty shall be inflicted in case of mutiny on the high seas. Article 123. Qualified piracy. The penalty of reclusion temporal to death shall be imposed upon those who commit any of the crimes referred to in the preceding article, under any of the following circumstances. 1. Whenever they have seized a vessel by boarding or firing upon the same. 2. Whenever the pirates have abandoned their victims without means of saving themselves, or 3. Whenever the crime is accompanied by murder, homicide, physical injuries or rape. Title II. Crimes against the fundamental laws of the state. Chapter 1. Arbitrary detention or expulsion, violation of dwelling, prohibition, interruption, and dissolution of peaceful meetings and crimes against religious worship. Section 1. Arbitrary detention and expulsion. Article 124. Arbitrary detention. Any public officer or employee who, without legal grounds, detains a person, shall suffer 1. The penalty of arrest mer in its maximum period to prison correctional in its minimum period, if the detention has not exceeded 3 days. 2. The penalty of prison correctional in its medium and maximum periods, if the detention has continued more than 3 but not more than 15 days. 3. The penalty of prison mer, if the detention has continued for more than 15 days but not more than 6 months, and 4. That of reclusion temporal, if the detention shall have exceeded 6 months. The commission of a crime, or violent insanity or any other ailment requiring the compulsory confinement of the patient in a hospital, shall be considered legal grounds for the detention of any person. Article 125. Delay in the delivery of detained persons to the proper judicial authorities. The penalties provided in the next preceding article shall be imposed upon the public officer or employee who shall detain any person for some legal ground and shall fail to deliver such person to the proper judicial authorities within the period of 12 hours, for crimes or offences punishable by light penalties, or their equivalent, 18 hours, for crimes or offences punishable by correctional penalties, or their equivalent, and 36 hours, for crimes or offences punishable by afflictive or capital penalties, or their equivalent. In every case, the person detained shall be informed of the cause of his detention and shall be allowed upon his request, to communicate and confer at any time with his attorney or counsel. As amended by Executive Order Nos. 59 and 272, November 7, 1986 and July 25, 1987, respectively. Article 126. Delaying release. The penalties provided for in Article 124 shall be imposed upon any public officer or employee who delays for the period of time specified therein the performance of any judicial or executive order for the release of a prisoner or detention prisoner, or unduly delays the service of the notice of such order to said prisoner or the proceedings upon any petition for the liberation of such person. Article 127. Expulsion. The penalty of prison correctional shall be imposed upon any public officer or employee who, not being thereunto authorized by law, shall expel any person from the Philippine Islands or shall compel such person to change his residence. Section 2. Violation of domicile. Article 128. Violation of domicile. The penalty of prison correctional in its minimum period shall be imposed upon any public officer or employee who, not being authorized by judicial order, shall enter any dwelling against the will of the owner thereof, search papers or other effects found therein without the previous consent of such owner, or having surreptitiously entered said dwelling, and being required to leave the premises, shall refuse to do so. If the offense be committed in the night time, or if any papers or effects not constituting evidence of a crime be not returned immediately after the search made by the offender, the penalty shall be prison correctional in its medium and maximum periods. Article 129. Search warrants maliciously obtained and abuse in the service of those legally obtained. In addition to the liability attaching to the offender for the commission of any other offense, the penalty of arrest in its maximum period to prison correctional in its minimum period and a fine not exceeding P1,000 pesos shall be imposed upon any public officer or employee who shall procure a search warrant without just cause, or, having legally procured the same, shall exceed his authority or use unnecessary severity in executing the same. Article 130. Searching domicile without witnesses. The penalty of arrest in its medium and maximum periods shall be imposed upon a public officer or employee who, in cases where a search is proper, shall search the domicile, papers or other belongings of any person, in the absence of the latter, any member of his family, or in their default, without the presence of two witnesses residing in the same locality. Section 3. Prohibition, interruption, and dissolution of peaceful meetings. Article 131. Prohibition, interruption and dissolution of peaceful meetings. The penalty of prison correctional in its minimum period shall be imposed upon any public officer or employee who, without legal ground, shall prohibit or interrupt the holding of a peaceful meeting, or shall dissolve the same. The same penalty shall be imposed upon a public officer or employee who shall hinder any person from joining any lawful association or from attending any of its meetings. The same penalty shall be imposed upon any public officer or employee who shall prohibit or hinder any person from addressing, either alone or together with others, any petition to the authorities for the correction of abuses or redress of grievances. Section 4. Crimes against religious worship. Article 132. Interruption of religious worship. The penalty of prison correctional in its minimum period shall be imposed upon any public officer or employee who shall prevent or disturb the ceremonies or manifestations of any religion. If the crime shall have been committed with violence or threats, the penalty shall be prison correctional in its medium and maximum periods. Article 133. Offending the religious feelings. The penalty of arrest in its maximum period to prison correctional in its minimum period shall be imposed upon anyone who, in a place devoted to religious worship or during the celebration of any religious ceremony shall perform acts notoriously offensive to the feelings of the faithful. Title 3. Crimes against public order. Chapter 1. Rebellion, sedition and disloyalty. Article 134. Rebellion or insurrection, how committed. The crime of rebellion or insurrection is committed by rising publicly and taking arms against the government for the purpose of removing from the allegiance to said government or its laws, the territory of the Philippine Islands or any part thereof, of any body of land, naval or other armed forces, depriving the chief executive or the legislature, wholly or partially, of any of their powers or prerogatives. As amended by Republic Act 6968. Article 134a. Coup d'état, how committed. The crime of coup d'état is a swift attack accompanied by violence, intimidation, threat, strategy or stealth, directed against duly constituted authorities of the Republic of the Philippines, or any military camp or installation, communications network, public utilities or other facilities needed for the exercise and continued possession of power, singly or simultaneously carried out anywhere in the Philippines by any person or persons, belonging to the military or police or holding any public office of employment with or without civilian support or participation for the purpose of seizing or diminishing state power. As amended by Republic Act 6968. Article 135. Penalty for rebellion, insurrection or coup d'état. Any person who promotes, maintains, or heads rebellion or insurrection shall suffer the penalty of reclusion perpetua. Any person merely participating or executing the commands of others in a rebellion shall suffer the penalty of reclusion temporal. Any person who leads or in any manner directs or commands others to undertake a coup d'état shall suffer the penalty of reclusion perpetua. Any person in the government service who participates, or executes directions or commands of others in undertaking a coup d'état shall suffer the penalty of prison mere in its maximum period. Any person not in the government service who participates, or in any manner supports, finances, abets or aids in undertaking a coup d'état shall suffer the penalty of reclusion temporal in its maximum period. When the rebellion, insurrection, or coup d'état shall be under the command of unknown leaders, any person who in fact directed the others, spoke for them, signed receipts and other documents issued in their name, has performed similar acts, on behalf of the rebels shall be deemed a leader of such a rebellion, insurrection, or coup d'état. As amended by Republic 6968, approved on October 24, 1990. Article 136. Conspiracy and proposal to commit coup d'état, rebellion or insurrection. The conspiracy and proposal to commit coup d'état shall be punished by prison mere in minimum period and a fine which shall not exceed 8,000 pesos. The conspiracy and proposal to commit rebellion or insurrection shall be punished respectively, by prison correctional in its maximum period and a fine which shall not exceed 5,000 pesos and by prison correctional in its medium period and a fine not exceeding 2,000 pesos, as amended by Republic Act 6968, approved October 24, 1990. Article 137. Disloyalty of public officers or employees. The penalty of prison correctional in its minimum period shall be imposed upon public officers or employees who have failed to resist rebellion by all the means in their power, or shall continue to discharge the duties of their offices under the control of the rebels or shall accept appointment to office under them. Reinstated by Executive Order No. 187. Article 138. Inciting a rebellion or insurrection. The penalty of prison mere in its minimum period shall be imposed upon any person who, without taking arms or being in open hostility against the government, shall incite others to the execution of any of the acts specified in Article 134 of this Code, by means of speeches, proclamations, writings, emblems, banners or other representations tending to the same end. Reinstated by Executive Order No. 187. Article 139. Sedition. How committed? The crime of sedition is committed by persons who rise publicly and tumultuously in order to attain by force, intimidation, or by other means outside of legal methods, any of the following objects. 1. To prevent the promulgation or execution of any law or the holding of any popular election. 2. To prevent the national government, or any provincial or municipal government or any public officer thereof from freely exercising its or his functions, or prevent the execution of any administrative order. 3. To inflict any act of hate or revenge upon the person or property of any public officer or employee. 4. To commit, for any political or social end, any act of hate or revenge against private persons or any social class, and 5. To despoil, for any political or social end, any person, municipality or province, or the national government, or the government of the United States, of all its property or any part thereof. Article 140. Penalty for sedition. The leader of a sedition shall suffer the penalty of prison mere in its minimum period and a fine not exceeding 10,000 pesos. Other persons participating therein shall suffer the penalty of prison correctional in its maximum period and a fine not exceeding 5,000 pesos. Reinstated by Executive Order No. 187. Article 141. Conspiracy to commit sedition. Persons conspiring to commit the crime of sedition shall be punished by prison correctional in its medium period and a fine not exceeding 2,000 pesos. Reinstated by Executive Order No. 187. Article 142. Inciting to sedition. The penalty of prison correctional in its maximum period and a fine not exceeding 2,000 pesos shall be imposed upon any person who, without taking any direct part in the crime of sedition, should incite others to the accomplishment of any of the acts which constitute sedition, by means of speeches, proclamations, writings, emblems, cartoons, banners, or other representations tending to the same end, or upon any person or persons who shall utter seditious words or speeches, write, publish, or circulate scurrilous libels against the government of the United States or the government of the Commonwealth of the Philippines, or any of the duly constituted authorities thereof, or which tend to disturb or obstruct any lawful officer in executing the functions of his office, or which tend to instigate others to cabal and meet together for unlawful purposes, or which suggest or incite rebellious conspiracies or riots, or which lead or tend to stir up the people against the lawful authorities or to disturb the peace of the community, the safety and order of the government, or who shall knowingly conceal such evil practices. Reinstated by Executive Order No. 187. Chapter 2. Crimes against popular representation. Section 1. Crimes against legislative bodies and similar bodies. Article 143. Act tending to prevent the meeting of the Assembly and similar bodies. The penalty of prison correctional or a fine ranging from 200 to 2,000 pesos, or both, shall be imposed upon any person who, by force or fraud, prevents the meeting of the National Assembly, Congress of the Philippines, or of any of its committees or subcommittees, constitutional commissions or committees or divisions thereof, or of any provincial board or city or municipal council or board. Reinstated by Executive Order No. 187. Article 144. Disturbance of Proceedings. The penalty of arresto mayor or a fine from 200 to 1,000 pesos shall be imposed upon any person who disturbs the meetings of the National Assembly, Congress of the Philippines, or of any of its committees or subcommittees, constitutional commissions or committees or divisions thereof, or of any provincial board or city or municipal council or board, or in the presence of any such bodies should behave in such manner as to interrupt its proceedings or to impair the respect due it. Reinstated by Executive Order No. 187. Section 2. Violation of parliamentary immunity. Article 145. Violation of parliamentary immunity. The penalty of prison mayor shall be imposed upon any person who shall use force, intimidation, threats, or fraud to prevent any member of the National Assembly, Congress of the Philippines, from attending the meetings of the Assembly, Congress, or of any of its committees or subcommittees, constitutional commissions or committees or divisions thereof, from expressing his opinions or casting his vote, and the penalty of prison correctional shall be imposed upon any public officer or employee who shall, while the Assembly, Congress, is in regular or special session, arrest or search any member thereof, except in case such member has committed a crime punishable under this code by a penalty higher than prison mayor. Chapter 3. Illegal Assemblies and Associations. Article 146. Illegal Assemblies. The penalty of prison correctional in its maximum period to prison mayor in its medium period shall be imposed upon the organizers or leaders of any meeting attended by armed persons for the purpose of committing any of the crimes punishable under this code, or of any meeting in which the audience is incited to the commission of the crime of treason, rebellion or insurrection, sedition or assault upon a person in authority or his agents. Persons merely present at such meetings shall suffer the penalty of arresto mayor, unless they are armed, in which case the penalty shall be prison correctional. If any person present at the meeting carries an unlicensed firearm, it shall be presumed that the purpose of said meeting, insofar as he is concerned, is to commit acts punishable under this code, and he shall be considered the leader or organizer of the meeting within the purview of the preceding paragraph. As used in this article, the word meeting shall be understood to include a gathering or group, whether in a fixed place or moving. Reinstated by Executive Order No. 187. Article 147. Illegal associations. The penalty of prison correctional in its minimum and medium periods and a fine not exceeding 1,000 pesos shall be imposed upon the founders, directors, and presidents of associations totally or partially organized for the purpose of committing any of the crimes punishable under this code or for some purpose contrary to public morals. Mere members of said associations shall suffer the penalty of arresto mea. Reinstated by Executive Order No. 187. Chapter 4. Assault upon, and resistance and disobedience. 2. Persons in authority and their agents. Article 148. Direct assaults. Any person or persons who, without a public uprising, shall employ force or intimidation for the attainment of any of the purpose enumerated in defining the crimes of rebellion and sedition, or shall attack, employ force, or seriously intimidate or resist any person in authority or any of his agents, while engaged in the performance of official duties, or on occasion of such performance, shall suffer the penalty of prison correctional in its medium and maximum periods and a fine not exceeding P1,000 pesos, when the assault is committed with a weapon or when the offender is a public officer or employee, or when the offender lays hands upon a person in authority. If none of these circumstances be present, the penalty of prison correctional in its minimum period and a fine not exceeding 500 pesos shall be imposed. Article 149. Indirect assaults. The penalty of prison correctional in its minimum and medium periods and a fine not exceeding 500 pesos shall be imposed upon any person who shall make use of force or intimidation upon any person coming to the aid of the authorities or their agents on occasion of the commission of any of the crimes defined in the next preceding article. Article 150. Disobedience to summons issued by the National Assembly, its committees or subcommittees, by the constitutional commissions, its committees, subcommittees or divisions. The penalty of arresto mea or a fine ranging from 200 to 1,000 pesos, or both such fine and imprisonment shall be imposed upon any person who, having been duly summoned to attend as a witness before the National Assembly, Congress, its special or standing committees and subcommittees, the constitutional commissions and its committees, subcommittees, or divisions, or before any commission or committee chairman or member authorized to summon witnesses, refuses, without legal excuse, to obey such summons, or being present before any such legislative or constitutional body or official, refuses to be sworn or placed under affirmation or to answer any legal inquiry or to produce any books, papers, documents, or records in his possession, when required by them to do so in the exercise of their functions. The same penalty shall be imposed upon any person who shall restrain another from attending as a witness, or who shall induce disobedience to a summon or refusal to be sworn by any such body or official. Article 151. Resistance and disobedience to a person in authority or the agents of such person. The penalty of arresto mea and a fine not exceeding 500 pesos shall be imposed upon any person who, not being included in the provisions of the preceding articles, shall resist or seriously disobey any person in authority, or the agents of such person, while engaged in the performance of official duties. When the disobedience to an agent of a person in authority is not of a serious nature, the penalty of arresto mea or a fine ranging from 10 to 100 pesos shall be imposed upon the offender. Article 152. Persons in authority and agents of persons in authority, who shall be deemed as such. In applying the provisions of the preceding and other articles of this code, any person directly vested with jurisdiction, whether as an individual or as a member of some court or governmental corporation, board, or commission, shall be deemed a person in authority. A barrio captain and a barangay chairman shall also be deemed a person in authority. A person who, by direct provision of law or by election or by appointment by competent authority, is charged with the maintenance of public order and the protection and security of life and property, such as a barrio councilman, barrio policeman and barangay leader, and any person who comes to the aid of persons in authority, shall be deemed an agent of a person in authority. In applying the provisions of Articles 148 and 151 of this Code, teachers, professors and persons charged with the supervision of public or duly recognized private schools, colleges and universities, and lawyers in the actual performance of their professional duties or on the occasion of such performance, shall be deemed persons in authority. As amended by Presidential Decree No. 299, September 19, 1973 and Batas Pambansa Bilang 873, June 12, 1985. Chapter 5. Public Disorders. Article 153. Tumults and other disturbance of public orders, tumultuous disturbance or interruption liable to cause disturbance. The penalty of arresto mere in its medium period to prison correctional in its minimum period and a fine not exceeding 1,000 pesos shall be imposed upon any person who shall cause any serious disturbance in a public place, office, or establishment, or shall interrupt or disturb public performances, functions or gatherings, or peaceful meetings, if the act is not included in the provisions of Articles 131 and 132. The penalty next higher in degree shall be imposed upon persons causing any disturbance or interruption of a tumultuous character. The disturbance or interruption shall be deemed to be tumultuous if caused by more than 3 persons who are armed or provided with means of violence. The penalty of arresto mere shall be imposed upon any person who in any meeting, association, or public place, shall make any outcry tending to incite rebellion or sedition, or in such place shall display placards or emblems which provoke a disturbance of the public order. The penalty of arresto mere and a fine not to exceed 200 pesos shall be imposed upon these persons who in violation of the provisions contained in the last clause of Article 85, shall bury with pomp the body of a person who has been legally executed. Article 154. Unlawful use of means of publication and unlawful utterances. The penalty of arresto mere and a fine ranging from 200 to 1,000 pesos shall be imposed upon 1. Any person who by means of printing, lithography, or any other means of publication shall publish or cause to be published as news any false news which may endanger the public order, or cause damage to the interest or credit of the state. 2. Any person who by the same means, or by words, utterances or speeches shall encourage disobedience to the law or to the constituted authorities or praise, justify, or extol any act punished by law. 3. Any person who shall maliciously publish or cause to be published any official resolution or document without proper authority, or before they have been published officially, or 4. Any person who shall print, publish, or distribute or cause to be printed, published, or distributed books, pamphlets, periodicals, or leaflets which do not bear the real printer's name, or which are classified as anonymous. Article 155. Alarms and scandals. The penalty of arresto mere or a fine not exceeding 200 pesos shall be imposed upon 1. Any person who within any town or public place shall discharge any firearm, rocket, firecracker, or other explosives calculated to cause alarm or danger. 2. Any person who shall instigate or take an active part in any charivari or other disorderly meeting offensive to another or prejudicial to public tranquility. 3. Any person who, while wandering about at night or while engaged in any other nocturnal amusements, shall disturb the public peace, or 4. Any person who, while intoxicated or otherwise, shall cause any disturbance or scandal in public places, provided that the circumstances of the case shall not make the provisions of Article 153 applicable. Article 156. Delivery of prisoners from jails. The penalty of arrest au maire in its maximum period of prison correctional in its minimum period shall be imposed upon any person who shall remove from any jail or penal establishment any person confined therein or shall help the escape of such person, by means of violence, intimidation, or bribery. If other means are used, the penalty of arrest au maire shall be imposed. If the escape of the prisoner shall take place outside of said establishments by taking the guards by surprise, the same penalties shall be imposed in their minimum period. Chapter 6. Evasion of Service of Sentence. Article 157. Evasion of Service of Sentence. The penalty of prison correctional in its medium and maximum periods shall be imposed upon any convict who shall evade service of his sentence by escaping during the term of his imprisonment by reason of final judgment. However, if such evasion or escape shall have taken place by means of unlawful entry, by breaking doors, windows, gates, walls, roofs, or floors, or by using picklocks, false keys, deceit, violence or intimidation, or through connivance with other convicts or employees of the penal institution, the penalty shall be prison correctional in its maximum period. Article 158. Evasion of service of sentence on the occasion of disorder, conflagrations, earthquakes, or other calamities. A convict who shall evade the service of his sentence, by leaving the penal institution where he shall have been confined, on the occasion of disorder resulting from a conflagration, earthquake, explosion, or similar catastrophe, or during a mutiny in which he has not participated, shall suffer an increase of 1/5 of the time still remaining to be served under the original sentence, which in no case shall exceed 6 months, if he shall fail to give himself up to the authorities within 48 hours following the issuance of a proclamation by the Chief Executive announcing the passing away of such calamity. Convicts who, under the circumstances mentioned in the preceding paragraph, shall give themselves up to the authorities within the above-mentioned period of 48 hours, shall be entitled to the deduction provided in Article 98. Article 159. Other cases of evasion of service of sentence. The penalty of prison correctional in its minimum period shall be imposed upon the convict who, having been granted conditional pardon by the Chief Executive, shall violate any of the conditions of such pardon. However, if the penalty remitted by the granting of such pardon be higher than 6 years, the convict shall then suffer the unexpired portion of his original sentence. Chapter 7. Commission of another crime during service of penalty imposed for another previous offense. Article 160. Commission of another crime during service of penalty imposed for another offense, penalty. Besides the provisions of Rule 5 of Article 62, any person who shall commit a felony after having been convicted by final judgment, before beginning to serve such sentence, or while serving the same, shall be punished by the maximum period of the penalty prescribed by law for the new felony. Any convict of the class referred to in this article, who is not a habitual criminal, shall be pardoned at the age of 70 years if he shall have already served out his original sentence, or when he shall complete it after reaching the said age, unless by reason of his conduct or other circumstances he shall not be worthy of such clemency. Title 4. Crimes against Public Interest. Chapter 1. Forgeries. Section 1. Forging the seal of the government of their Philippine Islands, the signature or stamp of the Chief Executive. Article 161. Counterfeiting the Great Seal of the Government of the Philippine Islands, forging the signature or stamp of the Chief Executive. The penalty of reclusion temporal shall be imposed upon any person who shall forge the Great Seal of the Government of the Philippine Islands or the signature or stamp of the Chief Executive. Article 162. Using forged signature or counterfeit seal or stamp. The penalty of prison maire shall be imposed upon any person who shall knowingly make use of the counterfeit seal or forged signature or stamp mentioned in the preceding article. Section 2. Counterfeiting coins. Article 163. Making and importing and uttering false coins. Any person who makes, imports, or utters false coins, in connivance with counterfeiters, or importers, shall suffer 1. Prison in its minimum and medium periods and a fine not to exceed 10,000 pesos, if the counterfeited coin be silver coin of the Philippines or coin of the Central Bank of the Philippines of 10 centavo denomination or above. 2. Prison correctional in its minimum and medium periods and a fine of not to exceed 2,000 pesos, if the counterfeited coins be any of the minor coinage of the Philippines or of the Central Bank of the Philippines below 10 centavo denomination. 3. Prison correctional in its minimum period and a fine not to exceed 1,000 pesos, if the counterfeited coin be currency of a foreign country. As amended by Republic Act No. 4202. Approved June 19, 1965. Article 164. Mutilation of coins, importation and utterance of mutilated coins. The penalty of prison correctional in its minimum period and a fine not to exceed 2,000 pesos shall be imposed upon any person who shall mutilate coins of the legal currency of the United States or of the Philippine Islands or import or utter mutilated current coins, or in connivance with mutilators or importers. Article 165. Selling of false or mutilated coin, without connivance. The person who knowingly, although without the connivance mentioned in the preceding articles, shall possess false or mutilated coin with intent to utter the same, or shall actually utter such coin, shall suffer a penalty lower by 1 degree than that prescribed in said articles. Section 3. Forging treasury or bank notes, obligations and securities, importing and uttering false or forged notes. Obligations and securities. Article 166. Forging treasury or bank notes on other documents payable to bearer, importing, and uttering such false or forged notes and documents. The forging or falsification of treasury or bank notes or certificates or other obligations and securities payable to bearer and the importation and uttering in connivance with forgers or importers of such false or forged obligations or notes, shall be punished as follows. 1. By reclusion temporal in its minimum period and a fine not to exceed 10,000 pesos, if the document which has been falsified, counterfeited, or altered, is an obligations or security of the United States or of the Philippines Islands. The word obligation or security of the United States or of the Philippine Islands shall be held to mean all bonds, certificates of indebtedness, national bank notes, fractional notes, certificates of deposit, bills, checks, or drafts for money, drawn by or upon authorized officers of the United States or of the Philippine Islands, and other representatives of value, of whatever denomination, which have been or may be issued under any act of the Congress of the United States or of the Philippine Legislature. 2. By prison in its maximum period and a fine not to exceed 5,000 pesos, if the falsified or altered document is a circulating note issued by any banking association duly authorized by law to issue the same. 3. By prison in its medium period and a fine not to exceed 5,000 pesos, if the falsified or counterfeited document was issued by a foreign government. 4. By prison in its minimum period and a fine not to exceed 2,000 pesos, when the forged or altered document is a circulating note or bill issued by a foreign bank duly authorized therefor. Article 167. Counterfeiting, importing and uttering instruments not payable to bearer. Any person who shall forge, import or utter, in connivance with the forgers or importers, any instrument payable to order or other document of credit not payable to bearer, shall suffer the penalties of prison correctional in its medium and maximum periods and a fine not exceeding 6,000 pesos. Article 168. Illegal possession and use of false treasury or bank notes and other instruments of credit. Unless the act be one of those coming under the provisions of any of the preceding articles, any person who shall knowingly use or have in his possession, with intent to use any of the false or falsified instruments referred to in this section, shall suffer the penalty next lower in degree than that prescribed in said articles. Article 169. How forgery is committed. The forgery referred to in this section may be committed by any of the following means. 1. By giving to a treasury or banknote or any instrument, payable to bearer or order mentioned therein, the appearance of a true genuine document. 2. By erasing, substituting, counterfeiting or altering by any means the figures, letters, words or signs contained therein. Section 4. Falsification of legislative, public, commercial, and private documents, and wireless, telegraph, and telephone message. Article 170. Falsification of legislative documents. The penalty of prison correctional in its maximum period and a fine not exceeding 6,000 pesos shall be imposed upon any person who, without proper authority therefore alters any bill, resolution, or ordinance enacted or approved or pending approval by either House of the Legislature or any provincial board or municipal council. Article 171. Falsification by public officer, employee or notary or ecclesiastic minister. The penalty of prison mere and a fine not to exceed 5,000 pesos shall be imposed upon any public officer, employee, or notary who, taking advantage of his official position, shall falsify a document by committing any of the following acts. 1. Counterfeiting or imitating any handwriting, signature or rubric. 2. Causing it to appear that persons have participated in any act or proceeding when they did not in fact so participate. 3. Attributing to persons who have participated in an act or proceeding statements other than those in fact made by them. 4. Making untruthful statements in a narration of facts. 5. Altering true dates. 6. Making any alteration or intercalation in a genuine document which changes its meaning. 7. Issuing in an authenticated form a document purporting to be a copy of an original document when no such original exists, or including in such a copy a statement contrary to, or different from, that of the genuine original, or 8. Intercalating any instrument or note relative to the issuance thereof in a protocol, registry, or official book. The same penalty shall be imposed upon any ecclesiastical minister who shall commit any of the offences enumerated in the preceding paragraphs of this article, with respect to any record or document of such character that its falsification may affect the civil status of persons. Article 172. Falsification by private individual and use of falsified documents. The penalty of prison correctional in its medium and maximum periods and a fine of not more than 5,000 pesos shall be imposed upon 1. Any private individual who shall commit any of the falsifications enumerated in the next preceding article in any public or official document or letter of exchange or any other kind of commercial document, and 2. Any person who, to the damage of a third party, or with the intent to cause such damage, shall in any private document commit any of the acts of falsification enumerated in the next preceding article. Any person who shall knowingly introduce in evidence in any judicial proceeding or to the damage of another or who, with the intent to cause such damage, shall use any of the false documents embraced in the next preceding article, or in any of the foregoing subdivisions of this article, shall be punished by the penalty next lower in degree. Article 173. Falsification of wireless, cable, telegraph and telephone messages, and use of said falsified messages. The penalty of prison correctional in its medium and maximum periods shall be imposed upon officer or employee of the government or of any private corporation or concern engaged in the service of sending or receiving wireless, cable or telephone message who utters a fictitious wireless, telegraph or telephone message of any system or falsifies the same. Any person who shall use such falsified dispatch to the prejudice of a third party or with the intent of cause such prejudice, shall suffer the penalty next lower in degree. Section 5. Falsification of medical certificates. Certificates of merit or services and the like. Article 174. false medical certificates, false certificates of merits or service, etc. The penalties of arresto mea in its maximum period to prison correctional in its minimum period and a fine not to exceed 1,000 pesos shall be imposed upon 1. Any physician or surgeon who, in connection with the practice of his profession, shall issue a false certificate, and 2. Any public officer who shall issue a false certificate of merit of service, good conduct or similar circumstances. The penalty of arresto mea shall be imposed upon any private person who shall falsify a certificate falling within the classes mentioned in the two preceding subdivisions. Article 175. Using false certificates. The penalty of arresto mea shall be imposed upon anyone who shall knowingly use any of the false certificates mentioned in the next preceding article. Section 6. Manufacturing, importing and possession of instruments or implements intended for the commission of falsification. Article 176. Manufacturing and possession of instruments or implements for falsification. The penalty of prison correctional in its medium and maximum periods and a fine not to exceed 10,000 pesos shall be imposed upon any person who shall make or introduce into the Philippine Islands any stamps, dies, marks, or other instruments or implements intended to be used in the commission of the offenses of counterfeiting or falsification mentioned in the preceding sections of this chapter. Any person who, with the intention of using them, shall have in his possession any of the instruments or implements mentioned in the preceding paragraphs, shall suffer the penalty next lower in degree than that provided therein. Chapter 2. Other falsifications. Section 1. Usurpation of authority, rank, title, and improper use of names, uniforms and insignia. Article 177. Usurpation of authority or official functions. Any person who shall knowingly and falsely represent himself to be an officer, agent or representative of any department or agency of the Philippine government or of any foreign government, or who, under pretense of official position, shall perform any act pertaining to any person in authority or public officer of the Philippine government or any foreign government, or any agency thereof, without being lawfully entitled to do so, shall suffer the penalty of prison correctional in its minimum and medium periods. Article 178. Using fictitious name and concealing true name. The penalty of arresto mea and a fine not to exceed 500 pesos shall be imposed upon any person who shall publicly use a fictitious name for the purpose of concealing a crime, evading the execution of a judgment or causing damage. Any person who conceals his true name and other personal circumstances shall be punished by arresto mea or a fine not to exceed 200 pesos. Article 179. Illegal use of uniforms or insignia. The penalty of arresto mea shall be imposed upon any person who shall publicly and improperly make use of insignia, uniforms or dress pertaining to an office not held by such person or to a class of persons of which he is not a member. Section 2. False testimony. Article 180. False testimony against a defendant. Any person who shall give false testimony against the defendant in any criminal case shall suffer 1. The penalty of reclusion temporal, if the defendant in said case shall have been sentenced to death. 2. The penalty of prison mea, if the defendant shall have been sentenced to reclusion temporal or reclusion perpetua. 3. The penalty of prison correctional, if the defendant shall have been sentenced to any other afflictive penalty, and 4. The penalty of arresto mea, if the defendant shall have been sentenced to a correctional penalty or a fine, or shall have been acquitted. In cases provided in subdivisions 3 and 4 of this article, the offender shall further suffer a fine not to exceed 1,000 pesos. Article 181. False testimony favorable to the defendants. Any person who shall give false testimony in favor of the defendant in a criminal case, shall suffer the penalties of arresto mea in its maximum period to prison correctional in its minimum period, a fine not to exceed 1,000 pesos, if the prosecution is for a felony punishable by an afflictive penalty, and the penalty of arrest or mere in any other case. Article 182. False testimony in civil cases. Any person found guilty of false testimony in a civil case shall suffer the penalty of prison correctional in its minimum period and a fine not to exceed 6,000 pesos, if the amount in controversy shall exceed 5,000 pesos, and the penalty of arrest or mere in its maximum period to prison correctional in its minimum period and a fine not to exceed 1,000 pesos, if the amount in controversy shall not exceed said amount or cannot be estimated. Article 183. False testimony in other cases and perjury in solemn affirmation. The penalty of arrest or mere in its maximum period to prison correctional in its minimum period shall be imposed upon any person who knowingly makes untruthful statements and not being included in the provisions of the next preceding articles, shall testify under oath, or make an affidavit, upon any material matter before a competent person authorized to administer an oath in cases in which the law so requires. Any person who, in case of a solemn affirmation made in lieu of an oath, shall commit any of the falsehoods mentioned in this and the 3 preceding articles of this section, shall suffer the respective penalties provided therein. Article 184. Offering false testimony in evidence. Any person who shall knowingly offer in evidence a false witness or testimony in any judicial or official proceeding, shall be punished as guilty of false testimony and shall suffer the respective penalties provided in this section. Chapter 3. FRAUDS. Section 1. Machinations, Monopolies and Combinations. Article 185. Machinations in public auctions. Any person who shall solicit any gift or promise as a consideration for refraining from taking part in any public auction, and any person who shall attempt to cause bidders to stay away from an auction by threats, gifts, promises, or any other artifice, with intent to cause the reduction of the price of the thing auctioned, shall suffer the penalty of prison correctional in its minimum period and a fine ranging from 10 to 50% of the value of the thing auctioned. Article 186. Monopolies and Combinations in Restraint of Trade. The penalty of prison correctional in its minimum period or a fine ranging from 200 to 6,000 pesos, or both, shall be imposed upon 1. Any person who shall enter into any contract or agreement or shall take part in any conspiracy or combination in the form of a trust or otherwise, in restraint of trade or commerce or to prevent by artificial means free competition in the market. 2. Any person who shall monopolize any merchandise or object of trade or commerce, or shall combine with any other person or persons to monopolize any merchandise or object in order to alter the price thereof by spreading false rumors or making use of any other article to restrain free competition in the market. 3. Any person who, being a manufacturer, producer, or processor of any merchandise or object of commerce or an importer of any merchandise or object of commerce from any foreign country, either as principal or agent, wholesaler or retailer, shall combine, conspire or agree in any manner with any person likewise engaged in the manufacture, production, processing, assembling or importation of such merchandise or object of commerce or with any other persons not so similarly engaged for the purpose of making transactions prejudicial to lawful commerce, or of increasing the market price in any part of the Philippines, of any such merchandise or object of commerce manufactured, produced, processed, assembled in or imported into the Philippines, or of any article in the manufacture of which such manufactured, produced, or imported merchandise or object of commerce is used. If the offense mentioned in this article affects any food substance, motor fuel or lubricants, or other articles of prime necessity, the penalty shall be that of prison mere in its maximum and medium periods, it being sufficient for the imposition thereof that the initial steps have been taken toward carrying out the purposes of the combination. Any property possessed under any contract or by any combination mentioned in the preceding paragraphs, and being the subject thereof, shall be forfeited to the government of the Philippines. Whenever any of the offenses described above is committed by a corporation or association, the President and each one of its agents or representatives in the Philippines in case of a foreign corporation or association, who shall have knowingly permitted or failed to prevent the commission of such offense, shall be held liable as principals thereof. Section 2. Frauds in Commerce and Industry. Article 187. Importation and disposition of falsely marked articles or merchandise made of gold, silver, or other precious metals or their alloys. The penalty of prison correctional or a fine ranging from 200 to 1,000 pesos, or both, shall be imposed on any person who shall knowingly import or sell or dispose of any article or merchandise made of gold, silver, or other precious metals, or their alloys, with stamps, brands, or marks which fail to indicate the actual fineness or quality of said metals or alloys. Any stamp, brand, label, or mark shall be deemed to fail to indicate the actual fineness of the article on which it is engraved, printed, stamped, labeled or attached, when the rest of the article shows that the quality or fineness thereof is less by more than 1/2 carat, if made of gold, and less by more than 4/1000, if made of silver, than what is shown by said stamp, brand, label or mark. But in case of watch cases and flatware made of gold, the actual fineness of such gold shall not be less by more than 3/1000 than the fineness indicated by said stamp, brand, label, or mark. Article 188. Subsisting and altering trademark, trade names, or service marks. The penalty of prison correctional in its minimum period or a fine ranging from 50 to 2,000 pesos, or both, shall be imposed upon 1. Any person who shall substitute the trade name or trademark of some other manufacturer or dealer or a colorable imitation thereof, for the trademark of the real manufacturer or dealer upon any article of commerce and shall sell the same. 2. Any person who shall sell such articles of commerce or offer the same for sale, knowing that the trade name or trademark has been fraudulently used in such goods as described in the preceding subdivision. 3. Any person who, in the sale or advertising of his services, shall use or substitute the service mark of some other person, or a colorable imitation of such mark, or 4. Any person who, knowing the purpose for which the trade name, trademark, or service mark of a person is to be used, prints, lithographs, or in any way reproduces such trade name, trademark, or service mark, or a colorable imitation thereof, for another person, to enable that other person to fraudulently use such trade name, trademark, or service mark on his own goods or in connection with the sale or advertising of his services. A trade name or trademark as herein used is a word or words, name, title, symbol, emblem, sign or device, or any combination thereof used as an advertisement, sign, label, poster, or otherwise, for the purpose of enabling the public to distinguish the business of the person who owns and uses said trade name or trademark. A service mark as herein used is a mark used in the sale or advertising of services to identify the services of one person and distinguish them from the services of others and includes without limitation the marks, names, symbols, titles, designations, slogans, character names, and distinctive features of radio or other advertising. Article 189. Unfair competition, fraudulent registration of trademark, trade name or service mark, fraudulent designation of origin, and false description. The penalty provided in the next preceding article shall be imposed upon 1. Any person who, in unfair competition and for the purposes of deceiving or defrauding another of his legitimate trade or the public in general, shall sell his goods giving them the general appearance of goods of another manufacturer or dealer, either as to the goods themselves, or in the wrapping of the packages in which they are contained or the device or words thereon or in any other features of their appearance which would be likely to induce the public to believe that the goods offered are those of a manufacturer or dealer other than the actual manufacturer or dealer or shall give other persons a chance or opportunity to do the same with a like purpose. 2. Any person who shall affix, apply, annex or use in connection with any goods or services or any container or containers for goods a false designation of origin or any false description or representation and shall sell such goods or services. 3. Any person who by means of false or fraudulent representation or declarations orally or in writing or by other fraudulent means shall procure from the Patent Office or from any other office which may hereafter be established by law for the purposes the registration of a trade name, trademark or service mark or of himself as the owner of such trade name, trademark or service mark or an entry respecting a trade name, trademark or service mark. Title 5. Crimes relative to opium and other prohibited drugs. Article 190. Possession, preparation and use of prohibited drugs and maintenance of opium dens. The penalty of arresto mere in its medium period to prison correctional in its minimum period and a fine ranging from 300 to 1,000 pesos shall be imposed upon 1. Anyone who unless lawfully authorized shall possess, prepare, administer, or otherwise use any prohibited drug. Prohibited drug, as used herein includes opium, cocaine, alpha and beta-eucaine, Indian hemp, their derivatives, and all preparations made from them or any of them, and such other drugs, whether natural or synthetic, having physiological action as a narcotic drug. Opium embraces every kind, class, and character of opium, whether crude or prepared, the ashes on refuse of the same, narcotic preparations thereof or therefrom, morphine or any alkaloid of opium, preparation in which opium, morphine or any kind of opium, enter as an ingredient, and also opium leaves or wrappings of opium leaves, whether prepared or not for their use. Indian hemp otherwise known as marijuana, cannabis, Americana, hashish, bhang, guarza, charus, and ganja embraces every kind, class and character of Indian hemp, whether dried or fresh, flowering or fruiting tops of the pistillate plant Cannabis sativa, from which the resin has not been extracted, including all other geographic varieties whether used as reefers, resin, extract, tincture or in any other form whatsoever. By narcotic drug is meant a drug that produces a condition of insensibility and melancholy dullness of mind with delusions and may be habit-forming. 2. Anyone who shall maintain a dive or resort where any prohibited drug is used in any form, in violation of the law. Article 191. Keeper, watchman and visitor of opium den. The penalty of arresto mere and a fine ranging from 100 to 300 pesos shall be imposed upon 1. Anyone who shall act as a keeper or watchman of a dive or resort where any prohibited drug is used in any manner contrary to law, and 2. Any person who, not being included in the provisions of the next preceding article, shall knowingly visit any dive or resort of the character referred to above. Article 192. Importation and sale of prohibited drugs. The penalty of prison correctional in its medium and maximum periods and a fine ranging from 300 to 10,000 pesos shall be imposed upon any person who shall import or bring into the Philippine Islands any prohibited drug. The same penalty shall be imposed upon any person who shall unlawfully sell or deliver to another prohibited drug. Article 193. Illegal possession of opium pipe or other paraphernalia for the use of any prohibited drug. The penalty of arresto mere and a fine not exceeding 500 pesos shall be imposed upon any person who, not being authorized by law, shall possess any opium pipe or other paraphernalia for smoking, injecting, administering or using opium or any prohibited drug. The illegal possession of an opium pipe or other paraphernalia for using any other prohibited drug shall be prima facie evidence that its possessor has used said drug. Article 194. Prescribing opium unnecessary for a patient. The penalty of prison correctional or a fine ranging from 300 to 10,000 pesos, or both shall be imposed upon any physician or dentist who shall prescribe opium for any person whose physical condition does not require the use of the same. Title 6. Crimes against public morals. Chapter 1. Gambling and betting. Article 195. What acts are punishable in gambling? A. The penalty of arresto mayor or a fine not exceeding 200 pesos, and, in case of recidivism, the penalty of arresto mayor or a fine ranging from 200 or 6,000 pesos, shall be imposed upon 1. Any person other than those referred to in subsections B and C, who, in any manner shall directly, or indirectly take part in any game of monte, juteng or any other form of lottery, policy, banking, or percentage game, dog races, or any other game of scheme the result of which depends wholly or chiefly upon chance or hazard, or wherein wagers consisting of money, articles of value or representative of value are made, or in the exploitation or use of any other mechanical invention or contrivance to determine by chance the loser or winner of money or any object or representative of value. 2. Any person who shall knowingly permit any form of gambling referred to in the preceding subdivision to be carried on in any uninhabited or uninhabited place of any building, vessel or other means of transportation owned or controlled by him. If the place where gambling is carried on has the reputation of a gambling place or that prohibited gambling is frequently carried on therein, the culprit shall be punished by the penalty provided for in this article in its maximum period. B. The penalty of prison correctional in its maximum degree shall be imposed upon the maintainer, conductor, or banker in a game of juteng or any similar game. C. The penalty of prison correctional in its medium degree shall be imposed upon any person who shall, knowingly and without lawful purpose, have in his possession and lottery list, paper or other matter containing letters, figures, signs or symbols which pertain to or are in any manner used in the game of juteng or any similar game which has taken place or about to take place. Article 196. Importation, sale and possession of lottery tickets or advertisements. The penalty of arresto mayor in its maximum period to prison correctional in its minimum period or a fine ranging from 200 to 2,000 pesos, or both, in the discretion of the court, shall be imposed upon any person who shall import into the Philippine Islands from any foreign place or port any lottery ticket or advertisement or, in connivance with the importer, shall sell or distribute the same. Any person who shall knowingly and with intent to use them, have in his possession lottery tickets or advertisements, or shall sell or distribute the same without connivance with the importer of the same, shall be punished by arresto mayor, or a fine not exceeding 200 pesos, or both, in the discretion of the court. The possession of any lottery ticket or advertisement shall be prima facie evidence of an intent to sell, distribute or use the same in the Philippine Islands. Article 197. Betting in sports contests. The penalty of arresto mayor or a fine not exceeding 200 pesos, or both, shall be imposed upon any person who shall bet money or any object or article of value or representative of value upon the result of any boxing or other sports contests. Article 198. Illegal betting on horse race. The penalty of arresto mayor or a fine not exceeding 200 pesos, or both, shall be imposed upon any person who except during the period allowed by law, shall be on horse races. The penalty of arresto mayor or a fine ranging from 200 to 2,000 pesos, or both, shall be imposed upon any person who, under the same circumstances, shall maintain or employ a totalizer or other device or scheme for betting on horse races or realizing any profit therefrom. For the purposes of this article, any race held in the same day at the same place shall be held punishable as a separate offense, and if the same be committed by any partnership, corporation or association, the president and the directors or managers thereof shall be deemed to be principals in the offense if they have consented to or knowingly tolerated its commission. Article 199. Illegal cockfighting. The penalty of arresto mayor or a fine not exceeding 200 pesos, or both, in the discretion of the court, shall be imposed upon 1. Any person who directly or indirectly participates in cockfights, by betting money or other valuable things, or who organizes cockfights at which bets are made, on a day other than those permitted by law. 2. Any person who directly or indirectly participates in cockfights, at a place other than a licensed cockpit. Click here for the full text of Presidential Decree No. 1602. Simplifying and providing stiffer penalties for violations of Philippine gambling laws. Chapter 2. Offenses against decency and good customs. Article 200. Grave scandal. The penalties of arrest au maire and public censure shall be imposed upon any person who shall offend against decency or good customs by any highly scandalous conduct not expressly falling within any other article of this code. Article 201. Immoral doctrines, obscene publications and exhibitions and indecent shows. The penalty of prison mayor or a fine ranging from 6,000 to 12,000 pesos, or both such imprisonment and fine, shall be imposed upon 1. Those who shall publicly expound or proclaim doctrines openly contrary to public morals. 2. A. The authors of obscene literature, published with their knowledge in any form, the editors publishing such literature, and the owners, operators of the establishment selling the same. B. Those who, in theaters, fairs, cinematographs or any other place, exhibit indecent or immoral plays, scenes, acts or shows, whether live or in film, which are prescribed by virtue hereof, shall include those which, 1. Glorify criminals or condone crimes, 2. Serve no other purpose but to satisfy the market for violence, lust or pornography, 3. Offend any race or religion, 4. Tend to abet traffic in and use of prohibited drugs, and 5. Are contrary to law, public order, morals, and good customs, established policies, lawful orders, decrees and edicts. 3. Those who shall sell, give away or exhibit films, prints, engravings, sculpture or literature which are offensive to morals. As amended by P.D. Nos. 960 and 969. Article 202. Vagrants and prostitutes, penalty. The following are vagrants. 1. Any person having no apparent means of subsistence, who has the physical ability to work and who neglects to apply himself or herself to some lawful calling. 2. Any person found loitering about public or semi-public buildings or places or trampling or wandering about the country or the streets without visible means of support. 3. Any idle or dissolute person who lodges in houses of ill fame, ruffians or pimps and those who habitually associate with prostitutes. 4. Any person who, not being included in the provisions of other articles of this code, shall be found loitering in any inhabited or uninhabited place belonging to another without any lawful or justifiable purpose. 5. Prostitutes. For the purposes of this article, women who, for money or profit, habitually indulge in sexual intercourse or lascivious conduct, are deemed to be prostitutes. Any person found guilty of any of the offenses covered by this article shall be punished by arrest au maire or a fine not exceeding 200 pesos, and in case of recidivism, by arrest au maire in its medium period to prison correctional in its minimum period or a fine ranging from 200 to 2,000 pesos, or both, in the discretion of the court. Title 7. Crimes committed by public officers. Chapter 1. Preliminary Provisions. Article 203. Who are public officers. For the purpose of applying the provisions of this and the preceding titles of this book, any person who, by direct provision of a law, popular election or appointment by competent authority, shall take part in the performance of public functions in the government of the Philippine Islands, shall perform in said government or in any of its branches public duties as an employee, agent or subordinate official, of any rank or class, shall be deemed to be a public officer. Chapter 2. Malfeasance and misfeasance in office. Section 1. Dereliction of duty. Article 204. Knowingly rendering unjust judgment. Any judge who shall knowingly render an unjust judgment in any case submitted to him for decision, shall be punished by prison mere and perpetual absolute disqualification. Article 205. Judgment rendered through negligence. Any judge who, by reason of inexcusable negligence or ignorance shall render a manifestly unjust judgment in any case submitted to him for decision shall be punished by arrest mere and temporary special disqualification. Article 206. Unjust interlocutory order. Any judge who shall knowingly render an unjust interlocutory order or decree shall suffer the penalty of arrest mere in its minimum period and suspension, but if he shall have acted by reason of inexcusable negligence or ignorance and the interlocutory order or decree be manifestly unjust, the penalty shall be suspension. Article 207. Malicious delay in the administration of justice. The penalty of prison correctional in its minimum period shall be imposed upon any judge guilty of malicious delay in the administration of justice. Article 208. Prosecution of offences, negligence and tolerance. The penalty of prison correctional in its minimum period and suspension shall be imposed upon any public officer, or officer of the law, who, in dereliction of the duties of his office, shall maliciously refrain from instituting prosecution for the punishment of violators of the law, or shall tolerate the commission of offences. Article 209. Betrayal of trust by an attorney or solicitor. Revelation of secrets. In addition to the proper administrative action, the penalty of prison correctional in its minimum period, or a fine ranging from 200 to 1,000 pesos, or both, shall be imposed upon any attorney at law or solicitor, procurador judicial, who, by any malicious breach of professional duty or of inexcusable negligence or ignorance, shall prejudice his client, or reveal any of the secrets of the latter learned by him in his professional capacity. The same penalty shall be imposed upon an attorney at law or solicitor, procurador judicial, who, having undertaken the defense of a client or having received confidential information from said client in a case, shall undertake the defense of the opposing party in the same case, without the consent of his first client. Section 2. Bribery. Article 210. Direct bribery. Any public officer who shall agree to perform an act constituting a crime, in connection with the performance of his official duties, in consideration of any offer, promise, gift or present received by such officer, personally or through the mediation of another, shall suffer the penalty of prison mere in its medium and maximum periods and a fine, of not less than the value of the gift and, not less than 3 times the value of the gift in addition to the penalty corresponding to the crime agreed upon, if the same shall have been committed. If the gift was accepted by the officer in consideration of the execution of an act which does not constitute a crime, and the officer executed said act, he shall suffer the same penalty provided in the preceding paragraph, and if said act shall not have been accomplished, the officer shall suffer the penalties of prison correctional, in its medium period and a fine of not less than twice the value of such gift. If the object for which the gift was received or promised was to make the public officer refrain from doing something which it was his official duty to do, he shall suffer the penalties of prison correctional in its maximum period and a fine, of not less than the value of the gift and, not less than 3 times the value of such gift. In addition to the penalties provided in the preceding paragraphs, the culprit shall suffer the penalty of special temporary disqualification. The provisions contained in the preceding paragraphs shall be made applicable to assessors, arbitrators, appraisal and claim commissioners, experts or any other persons performing public duties. As amended by Batas Pambansa Bilang 872, June 10, 1985. Article 211. Indirect bribery. The penalties of prison correctional in its medium and maximum periods, and public censure shall be imposed upon any public officer who shall accept gifts offered to him by reason of his office. As amended by Batas Pambansa Bilang 872, June 10, 1985. Article 212. Corruption of public officials. The same penalties imposed upon the officer corrupted, except those of disqualification and suspension, shall be imposed upon any person who shall have made the offers or promises or given the gifts or presents as described in the preceding articles. Chapter 3. Frauds and illegal exactions and transactions. Article 213. Frauds against the public treasury and similar offences. The penalty of prison correctional in its medium period to prison mere in its minimum period, or a fine ranging from 200 to 10,000 pesos, or both, shall be imposed upon any public officer who 1. In his official capacity, in dealing with any person with regard to furnishing supplies, the making of contracts, or the adjustment or settlement of accounts relating to public property or funds, shall enter into an agreement with any interested party or speculator or make use of any other scheme, to defraud the government. 2. Being entrusted with the collection of taxes, licenses, fees and other imposts, shall be guilty of any of the following acts or omissions. A. Demanding, directly, or indirectly, the payment of sums different from or larger than those authorized by law. B. Failing voluntarily to issue a receipt, as provided by law, for any sum of money collected by him officially. C. Collecting or receiving, directly or indirectly, by way of payment or otherwise things or objects of a nature different from that provided by law. When the culprit is an officer or employee of the Bureau of Internal Revenue or the Bureau of Customs, the provisions of the Administrative Code shall be applied. Article 214. Other frauds. In addition to the penalties prescribed in the provisions of Chapter 6, Title 10, Book 2, of this Code, the penalty of temporary special disqualification in its maximum period to perpetual special disqualification shall be imposed upon any public officer who, taking advantage of his official position, shall commit any of the frauds or deceits enumerated in said provisions. Article 215. Prohibited transactions. The penalty of prison correctional in its maximum period or a fine ranging from 200 to 1,000 pesos, or both, shall be imposed upon any appointed public officer who, during his incumbency, shall directly or indirectly become interested in any transaction of exchange or speculation within the territory subject to his jurisdiction. Article 216. Possession of prohibited interest by a public officer. The penalty of arresto mere in its medium period to prison correctional in its minimum period, or a fine ranging from 200 to 1,000 pesos, or both, shall be imposed upon a public officer who directly or indirectly, shall become interested in any contract or business in which it is his official duty to intervene. This provisions is applicable to experts, arbitrators and private accountants who, in like manner, shall take part in any contract or transaction connected with the estate or property in appraisal, distribution or adjudication of which they shall have acted, and to the guardians and executors with respect to the property belonging to their wards or estate. Chapter 4. Malversation of public funds or property. Article 217. Malversation of public funds or property. Presumption of malversation. Any public officer who, by reason of the duties of his office, is accountable for public funds or property, shall appropriate the same or shall take or misappropriate or shall consent, through abandonment or negligence, shall permit any other person to take such public funds, or property, wholly or partially, or shall otherwise be guilty of the misappropriation or malversation of such funds or property, shall suffer 1. The penalty of prison correctional in its medium and maximum periods, if the amount involved in the misappropriation or malversation does not exceed 200 pesos. 2. The penalty of prison mere in its minimum and medium periods, if the amount involved is more than 200 pesos but does not exceed 6,000 pesos. 3. The penalty of prison mere in its maximum period to reclusion temporal in its minimum period, if the amount involved is more than 6,000 pesos but is less than 12,000 pesos. 4. The penalty of reclusion temporal, in its medium and maximum periods, if the amount involved is more than 12,000 pesos but is less than 22,000 pesos. If the amount exceeds the latter, the penalty shall be reclusion temporal in its maximum period to reclusion perpetua. In all cases, persons guilty of malversation shall also suffer the penalty of perpetual special disqualification and a fine equal to the amount of the funds malversed or equal to the total value of the property embezzled. The failure of a public officer to have duly forthcoming any public funds or property with which he is chargeable, upon demand by any duly authorized officer, shall be prima facie evidence that he has put such missing funds or property to personal use. As amended by RA 1060. Article 218. Failure of accountable officer to render accounts. Any public officer, whether in the service or separated therefrom by resignation or any other cause, who is required by law or regulation to render account to the insular auditor, or to a provincial auditor and who fails to do so for a period of 2 months after such accounts should be rendered, shall be punished by prison correctional in its minimum period, or by a fine ranging from 200 to 6,000 pesos, or both. Article 219. Failure of a responsible public officer to render accounts before leaving the country. Any public officer who unlawfully leaves or attempts to leave the Philippine Islands without securing a certificate from the insular auditor showing that his accounts have been finally settled, shall be punished by arresto mea, or a fine ranging from 200 to 1,000 pesos or both. Article 220. Illegal use of public funds or property. Any public officer who shall apply any public fund or property under his administration to any public use other than for which such fund or property were appropriated by law or ordinance shall suffer the penalty of prison correctional in its minimum period or a fine ranging from 1/2 to the total of the sum misapplied, if by reason of such misapplication, any damages or embarrassment shall have resulted to the public service. In either case, the offender shall also suffer the penalty of temporary special disqualification. If no damage or embarrassment to the public service has resulted, the penalty shall be a fine from 5 to 50% of the sum misapplied. Article 221. Failure to make delivery of public funds or property. Any public officer under obligation to make payment from government funds in his possession, who shall fail to make such payment, shall be punished by arresto mea and a fine from 5 to 25% of the sum which he failed to pay. This provision shall apply to any public officer who, being ordered by competent authority to deliver any property in his custody or under his administration, shall refuse to make such delivery. The fine shall be graduated in such case by the value of the thing, provided that it shall not less than 50 pesos. Article 222. Officers included in the preceding provisions. The provisions of this chapter shall apply to private individuals who in any capacity whatever, have charge of any insular, provincial or municipal funds, revenues, or property and to any administrator or depository of funds or property attached, seized or deposited by public authority, even if such property belongs to a private individual. Chapter 5. Infidelity of public officers. Section 1. Infidelity in the custody of prisoners. Article 223. Conniving with or consenting to evasion. Any public officer who shall consent to the escape of a prisoner in his custody or charge, shall be punished. 1. By prison correctional in its medium and maximum periods and temporary special disqualification in its maximum period to perpetual special disqualification, if the fugitive shall have been sentenced by final judgment to any penalty. 2. By prison correctional in its minimum period and temporary special disqualification, in case the fugitive shall not have been finally convicted but only held as a detention prisoner for any crime or violation of law or municipal ordinance. Article 224. Evasion through negligence. If the evasion of the prisoner shall have taken place through the negligence of the officer charged with the conveyance or custody of the escaping prisoner, said officer shall suffer the penalties of arresto mea in its maximum period to prison correctional in its minimum period and temporary special disqualification. Article 225. Escape of prisoner under the custody of a person not a public officer. Any private person to whom the conveyance or custody or a prisoner or person under arrest shall have been confided, who shall commit any of the offences mentioned in the two preceding articles, shall suffer the penalty next lower in degree than that prescribed for the public officer. Section 2. Infidelity in the custody of document. Article 226. Removal, concealment or destruction of documents. Any public officer who shall remove, destroy or conceal documents or papers officially entrusted to him, shall suffer 1. The penalty of prison under fine not exceeding 1,000 pesos, whenever serious damage shall have been caused thereby to a third party or to the public interest. 2. The penalty of prison correctional in its minimum and medium period and a fine not exceeding 1,000 pesos, whenever the damage to a third party or to the public interest shall not have been serious. In either case, the additional penalty of temporary special disqualification in its maximum period to perpetual disqualification shall be imposed. Article 227. Officer breaking seal. Any public officer charged with the custody of papers or property sealed by proper authority, who shall break the seals or permit them to be broken, shall suffer the penalties of prison correctional in its minimum and medium periods, temporary special disqualification and a fine not exceeding 2,000 pesos. Article 228. Opening of closed documents. Any public office not included in the provisions of the next preceding article who, without proper authority, shall open or shall permit to be opened any closed papers, documents or objects entrusted to his custody, shall suffer the penalties or arresto mea, temporary special disqualification and a fine of not exceeding 2,000 pesos. Section 3. Revelation of secrets. Article 229. Revelation of secrets by an officer. Any public officer who shall reveal any secret known to him by reason of his official capacity, or shall wrongfully deliver papers or copies of papers of which he may have charge and which should not be published, shall suffer the penalties of prison correctional in its medium and maximum periods, perpetual special disqualification and a fine not exceeding 2,000 pesos if the revelation of such secrets or the delivery of such papers shall have caused serious damage to the public interest. Otherwise, the penalties of prison correctional in its minimum period, temporary special disqualification and a fine not exceeding 50 pesos shall be imposed. Article 230. Public officer revealing secrets of private individual. Any public officer to whom the secrets of any private individual shall become known by reason of his office who shall reveal such secrets, shall suffer the penalties of arresto mea and a fine not exceeding 1,000 pesos. Chapter 6. Other offences or irregularities by public officers. Article 231. Open disobedience. Any judicial or executive officer who shall openly refuse to execute the judgment, decision or order of any superior authority made within the scope of the jurisdiction of the latter and issued with all the legal formalities, shall suffer the penalties of arresto mea in its medium period to prison correctional in its minimum period, temporary special disqualification in its maximum period and a fine not exceeding 1,000 pesos. Article 232. Disobedience to order of superior officers, when said order was suspended by inferior officer. Any public officer who, having for any reason suspended the execution of the orders of his superiors, shall disobey such superiors after the latter have disapproved the suspension, shall suffer the penalties of prison correctional in its minimum and medium periods and perpetual special disqualification. Article 233. Refusal of assistance. The penalties of arresto mea in its medium period to prison correctional in its minimum period, perpetual special disqualification and a fine not exceeding 1,000 pesos, shall be imposed upon a public officer who, upon demand from competent authority, shall fail to lend his cooperation towards the administration of justice or other public service, if such failure shall result in serious damage to the public interest, or to a third party. Otherwise, arrest or mayor in its medium and maximum periods, and a fine not exceeding 500 pesos shall be imposed. Article 234. Refusal to discharge elective office. The penalty of arrest or mayor or a fine not exceeding 1,000 pesos, or both, shall be imposed upon any person who, having been elected by popular election to a public office, shall refuse without legal motive to be sworn in or to discharge the duties of said office. Article 235. Maltreatment of prisoners. The penalty of arrest or mayor in its medium period to prison correctional in its minimum period, in addition to his liability for the physical injuries or damage caused, shall be imposed upon any public officer or employee who shall overdo himself in the correction or handling of a prisoner or detention prisoner under his charge, by the imposition of punishment not authorized by the regulations, or by inflicting such punishment in a cruel and humiliating manner. If the purpose of the maltreatment is to extort a confession, or to obtain some information from the prisoner, the offender shall be punished by prison correctional in its minimum period, temporary special disqualification and a fine not exceeding 500 pesos, in addition to his liability for the physical injuries or damage caused. Section 2. Anticipation, prolongation, and abandonment of the duties and powers of public office. Article 236. Anticipation of duties of a public office. Any person who shall assume the performance of the duties and powers of any public officer or employment without first being sworn in or having given the bond required by law, shall be suspended from such office or employment until he shall have complied with the respective formalities and shall be fined from 200 to 500 pesos. Article 237. Prolonging performance of duties and powers. Any public officer shall continue to exercise the duties and powers of his office, employment or commission, beyond the period provided by law, regulation or special provisions applicable to the case, shall suffer the penalties of prison correctional in its minimum period, special temporary disqualification in its minimum period and a fine not exceeding 500 pesos. Article 238. Abandonment of office or position. Any public officer who, before the acceptance of his resignation, shall abandon his office to the detriment of the public service shall suffer the penalty of arrest or mayor. If such office shall have been abandoned in order to evade the discharge of the duties of preventing, prosecuting or punishing any of the crime falling within Title I, and Chapter 1 of Title III of Book 2 of this Code, the offender shall be punished by prison correctional in its minimum and medium periods, and by arrest or mayor if the purpose of such abandonment is to evade the duty of preventing, prosecuting or punishing any other crime. Section 3. Usurpation of powers and unlawful appointments. Article 239. Usurpation of legislative powers. The penalties of prison correctional in its minimum period, temporary special disqualification and a fine not exceeding 1,000 pesos, shall be imposed upon any public officer who shall encroach upon the powers of the legislative branch of the government, either by making general rules or regulations beyond the scope of his authority, or by attempting to repeal a law or suspending the execution thereof. Article 240. Usurpation of executive functions. Any judge who shall assume any power pertaining to the executive authorities, or shall obstruct the latter in the lawful exercise of their powers, shall suffer the penalty of arrest or mayor in its medium period to prison correctional in its minimum period. Article 241. Usurpation of judicial functions. The penalty of arrest or mayor in its medium period to prison correctional in its minimum period and shall be imposed upon any officer of the executive branch of the government who shall assume judicial powers or shall obstruct the execution of any order or decision rendered by any judge within its jurisdiction. Article 242. Disobeying request for disqualification. Any public officer who, before the question of jurisdiction is decided, shall continue any proceeding after having been lawfully required to refrain from so doing, shall be punished by arrest or mayor and a fine not exceeding 500 pesos. Article 243. Orders or requests by executive officers to any judicial authority. Any executive officer who shall address any order or suggestion to any judicial authority with respect to any case or business coming within the exclusive jurisdiction of the courts of justice shall suffer the penalty of arresto mayor and a fine not exceeding 500 pesos. Article 244. Unlawful appointments. Any public officer who shall knowingly nominate or appoint to any public office any person lacking the legal qualifications therefor, shall suffer the penalty of arresto mayor and a fine not exceeding 1,000 pesos. Section 4. Abuses against chastity. Article 245. Abuses against chastity, penalties. The penalties of prison correctional in its medium and maximum periods and temporary special disqualification shall be imposed. 1. Upon any public officer who shall solicit or make immoral or indecent advances to a woman interested in matters pending before such officer for decision, or with respect to which he is required to submit a report to or consult with a superior officer. 2. Any warden or other public officer directly charged with the care and custody of prisoners or persons under arrest who shall solicit or make immoral or indecent advances to a woman under his custody. If the person solicited be the wife, daughter, sister of relative within the same degree by affinity of any person in the custody of such warden or officer, the penalties shall be prison correctional in its minimum and medium periods and temporary special disqualification. Title 8. Crimes Against Persons. Chapter 1. Destruction of Life. Section 1. Parricide, Murder, Homicide. Article 246. Parricide. Any person who shall kill his father, mother, or child, whether legitimate or illegitimate, or any of his ascendants, or descendants, or his spouse, shall be guilty of parricide and shall be punished by the penalty of reclusion perpetua to death. Article 247. Death or physical injuries inflicted under exceptional circumstances. Any legally married person who, having surprised his spouse in the act of committing sexual intercourse with another person, shall kill any of them or both of them in the act or immediately thereafter, or shall inflict upon them any serious physical injury, shall suffer the penalty of destierro. If he shall inflict upon them physical injuries of any other kind, he shall be exempt from punishment. These rules shall be applicable, under the same circumstances, to parents with respect to their daughters under 18 years of age, and their seducer, while the daughters are living with their parents. Any person who shall promote or facilitate the prostitution of his wife or daughter, or shall otherwise have consented to the infidelity of the other spouse shall not be entitled to the benefits of this article. Article 248. Murder. Any person who, not falling within the provisions of Article 246 shall kill another, shall be guilty of murder and shall be punished by reclusion temporal in its maximum period to death, if committed with any of the following attendant circumstances. 1. With treachery, taking advantage of superior strength, with the aid of armed men, or employing means to weaken the defense or of means or persons to ensure or afford impunity. 2. In consideration of a price, reward, or promise. 3. By means of inundation, fire, poison, explosion, shipwreck, stranding of a vessel, derailment or assault upon a streetcar or locomotive, fall of an airship, by means of motor vehicles, or with the use of any other means involving great waste and ruin. 4. On occasion of any of the calamities enumerated in the preceding paragraph, or of an earthquake, eruption of a volcano, destructive cyclone, epidemic or other public calamity. 5. With evident premeditation. 6. With cruelty, by deliberately and inhumanly augmenting the suffering of the victim, or outraging or scoffing at his person or corpse. Article 249. Homicide. Any person who, not falling within the provisions of Article 246, shall kill another without the attendance of any of the circumstances enumerated in the next preceding article, shall be deemed guilty of homicide and be punished by reclusion temporal. Article 250. Penalty for frustrated parricide, murder or homicide. The courts, in view of the facts of the case, may impose upon the person guilty of the frustrated crime of parricide, murder or homicide, defined and penalized in the preceding articles, a penalty lower by 1 degree than that which should be imposed under the provision of Article 50. The courts, considering the facts of the case, may likewise reduce by 1 degree the penalty which under Article 51 should be imposed for an attempt to commit any of such crimes. Article 251. Death caused in a tumultuous affray. When, while several persons, not composing groups organized for the common purpose of assaulting and attacking each other reciprocally, quarrel and assault each other in a confused and tumultuous manner, and in the course of the affray someone is killed, and it cannot be ascertained who actually killed the deceased, but the person or persons who inflicted serious physical injuries can be identified, such person or persons shall be punished by prison mare. If it cannot be determined who inflicted the serious physical injuries on the deceased, the penalty of prison correctional in its medium and maximum periods shall be imposed upon all those who shall have used violence upon the person of the victim. Article 252. Physical injuries inflicted in a tumultuous affray. When in a tumultuous affray as referred to in the preceding article, only serious physical injuries are inflicted upon the participants thereof and the person responsible thereof cannot be identified, all those who appear to have used violence upon the person of the offended party shall suffer the penalty next lower in degree than that provided for the physical injuries so inflicted. When the physical injuries inflicted are of a less serious nature and the person responsible therefore cannot be identified, all those who appear to have used any violence upon the person of the offended party shall be punished by arrest au maire from 5 to 15 days. Article 253. Giving assistance to suicide. Any person who shall assist another to commit suicide shall suffer the penalty of prison mare. If such person leads his assistance to another to the extent of doing the killing himself, he shall suffer the penalty of reclusion temporal. However, if the suicide is not consummated, the penalty of arrest au maire in its medium and maximum periods shall be imposed. Article 254. Discharge of firearms. Any person who shall shoot at another with any firearm shall suffer the penalty of prison correctional in its minimum and medium periods, unless the facts of the case are such that the act can be held to constitute frustrated or attempted parricide, murder, homicide or any other crime for which a higher penalty is prescribed by any of the articles of this code. Section 2. Infanticide and abortion. Article 255. Infanticide. The penalty provided for parricide in Article 246 and for murder in Article 248 shall be imposed upon any person who shall kill any child less than 3 days of age. If the crime penalized in this article be committed by the mother of the child for the purpose of concealing her dishonor, she shall suffer the penalty of prison correctional in its medium and maximum periods, and if said crime be committed for the same purpose by the maternal grandparents or either of them, the penalty shall be prison mare. Article 256. Intentional abortion. Any person who shall intentionally cause an abortion shall suffer 1. The penalty of reclusion temporal, if he shall use any violence upon the person of the pregnant woman. 2. The penalty of prison mare if, without using violence, he shall act without the consent of the woman. 3. The penalty of prison correctional in its medium and maximum periods, if the woman shall have consented. Article 257. Unintentional abortion. The penalty of prison correctional in its minimum and medium period shall be imposed upon any person who shall cause an abortion by violence, but unintentionally. Article 258. Abortion practiced by the woman herself or by her parents. The penalty of prison correctional in its medium and maximum periods shall be imposed upon a woman who shall practice abortion upon herself or shall consent that any other person should do so. Any woman who shall commit this offense to conceal her dishonor, shall suffer the penalty of prison correctional in its minimum and medium periods. If this crime be committed by the parents of the pregnant woman or either of them, and they act with the consent of said woman for the purpose of concealing her dishonor, the offenders shall suffer the penalty of prison correctional in its medium and maximum periods. Article 259. Abortion practiced by a physician or midwife and dispensing of abortives. The penalties provided in Article 256 shall be imposed in its maximum period, respectively, upon any physician or midwife who, taking advantage of their scientific knowledge or skill, shall cause an abortion or assist in causing the same. Any pharmacist who, without the proper prescription from a physician, shall dispense any abortive shall suffer arresto mea and a fine not exceeding 1,000 pesos. Section 3. Duel. Article 260. Responsibility of participants in a duel. The penalty of reclusion temporal shall be imposed upon any person who shall kill his adversary in a duel. If he shall inflict upon the latter physical injuries only, he shall suffer the penalty provided therefor, according to their nature. In any other case, the combatants shall suffer the penalty of arresto mea, although no physical injuries have been inflicted. The seconds shall in all events be punished as accomplices. Article 261. Challenging to a duel. The penalty of prison correctional in its minimum period shall be imposed upon any person who shall challenge another, or incite another to give or accept a challenge to a duel, or shall scoff at or decry another publicly for having refused to accept a challenge to fight a duel. Chapter 2. Physical injuries. Article 262. Mutilation. The penalty of reclusion temporal to reclusion perpetua shall be imposed upon any person who shall intentionally mutilate another by depriving him, either totally or partially, or some essential organ of reproduction. Any other intentional mutilation shall be punished by prison mea in its medium and maximum periods. Article 263. Serious physical injuries. Any person who shall wound, beat, or assault another, shall be guilty of the crime of serious physical injuries and shall suffer 1. The penalty of prison mea, if in consequence of the physical injuries inflicted, the injured person shall become insane, imbecile, impotent, or blind. 2. The penalty of prison correctional in its medium and maximum periods, if in consequence of the physical injuries inflicted, the person injured shall have lost the use of speech or the power to hear or to smell, or shall have lost an eye, a hand, a foot, an arm, or a leg, or shall have lost the use of any such member, or shall have become incapacitated for the work in which he was therefore habitually engaged. 3. The penalty of prison correctional in its minimum and medium periods, if in consequence of the physical injuries inflicted, the person injured shall have become deformed, or shall have lost any other part of his body, or shall have lost the use thereof, or shall have been ill or incapacitated for the performance of the work in which he is habitually engaged for a period of more than 90 days. 4. The penalty of arresto mea in its maximum period to prison correctional in its minimum period, if the physical injuries inflicted shall have caused the illness or incapacity for labor of the injured person for more than 30 days. If the offense shall have been committed against any of the persons enumerated in Article 246, or with attendance of any of the circumstances mentioned in Article 248, the case covered by subdivision number 1 of this article shall be punished by reclusion temporal in its medium and maximum periods, the case covered by subdivision number 2 by prison correctional in its maximum period to prison mea in its minimum period, the case covered by subdivision number 3 by prison correctional in its medium and maximum periods, and the case covered by subdivision number 4 by prison correctional in its minimum and medium periods. The provisions of the preceding paragraph shall not be applicable to a parent who shall inflict physical injuries upon his child by excessive chastisement. Article 264. Administering injurious substances or beverages. The penalties established by the next preceding article shall be applicable in the respective case to any person who, without intent to kill, shall inflict upon another any serious physical injury, by knowingly administering to him any injurious substance or beverages, or by taking advantage of his weakness of mind or credulity. Article 265. Less serious physical injuries. Any person who shall inflict upon another physical injuries not described in the preceding articles, but which shall incapacitate the offended party for labor for 10 days or more, or shall require medical assistance for the same period, shall be guilty of less serious physical injuries and shall suffer the penalty of arresto mea. Whenever less serious physical injuries shall have been inflicted with the manifest intent to kill or offend the injured person, or under circumstances adding ignominy to the offense in addition to the penalty of arresto mea, a fine not exceeding 500 pesos shall be imposed. Any less serious physical injuries inflicted upon the offender's parents, ascendants, guardians, curators, teachers, or persons of rank, or persons in authority, shall be punished by prison correctional in its minimum and medium periods, provided that, in the case of persons in authority, the deed does not constitute the crime of assault upon such person. Article 266. Slight physical injuries and maltreatment. The crime of slight physical injuries shall be punished. 1. By arresto mea when the offender has inflicted physical injuries which shall incapacitate the offended party for labor from 1 to 9 days, or shall require medical attendance during the same period. 2. By arresto mea or a fine not exceeding 20 pesos and censure when the offender has caused physical injuries which do not prevent the offended party from engaging in his habitual work nor require medical assistance. 3. By arresto mea in its minimum period or a fine not exceeding 50 pesos when the offender shall ill-treat another by deed without causing any injury. Title 9. Crimes against personal liberty and security. Chapter 1. Crimes against liberty. Article 267. Kidnapping and serious illegal detention. Any private individual who shall kidnap or detain another, or in any other manner deprive him of his liberty, shall suffer the penalty of reclusion perpetua to death. 1. If the kidnapping or detention shall have lasted more than 5 days. 2. If it shall have been committed simulating public authority. 3. If any serious physical injuries shall have been inflicted upon the person kidnapped or detained, or if threats to kill him shall have been made. 4. If the person kidnapped or detained shall be a minor, female or a public officer. The penalty shall be death where the kidnapping or detention was committed for the purpose of extorting ransom from the victim or any other person, even if none of the circumstances above mentioned were present in the commission of the offense. Article 268. Slight illegal detention. The penalty of reclusion temporal shall be imposed upon any private individual who shall commit the crimes described in the next preceding article without the attendance of any of circumstances enumerated therein. The same penalty shall be incurred by anyone who shall furnish the place for the perpetration of the crime. If the offender shall voluntarily release the person so kidnapped or detained within 3 days from the commencement of the detention, without having attained the purpose intended, and before the institution of criminal proceedings against him, the penalty shall be prison mea in its minimum and medium periods and a fine not exceeding 700 pesos. Article 269. Unlawful arrest. The penalty of arresto mea and a fine not exceeding 500 pesos shall be imposed upon any person who, in any case other than those authorized by law, or without reasonable ground therefore, shall arrest or detain another for the purpose of delivering him to the proper authorities. Section 2. Kidnapping of minors. Article 270. Kidnapping and failure to return a minor. The penalty of reclusion perpetua shall be imposed upon any person who, being entrusted with the custody of a minor person, shall deliberately fail to restore the latter to his parents or guardians. Article 271. Inducing a minor to abandon his home. The penalty of prison correctional and a fine not exceeding 700 pesos shall be imposed upon anyone who shall induce a minor to abandon the home of his parent or guardians or the persons entrusted with his custody. If the person committing any of the crimes covered by the two preceding articles shall be the father or the mother of the minor, the penalty shall be arresto mayor or a fine not exceeding 300 pesos, or both. Article 272. Slavery. The penalty of prison mayor and a fine of not exceeding 10,000 pesos shall be imposed upon anyone who shall purchase, sell, kidnap or detain a human being for the purpose of enslaving him. If the crime be committed for the purpose of assigning the offended party to some immoral traffic, the penalty shall be imposed in its maximum period. Article 273. Exploitation of child labor. The penalty of prison correctional in its minimum and medium periods and a fine not exceeding 500 pesos shall be imposed upon anyone who, under the pretext of reimbursing himself of a debt incurred by an ascendant, guardian or person entrusted with the custody of a minor, shall, against the latter's will, retain him in his service. Article 274. Services rendered under compulsion in payment of debt. The penalty of arresto mayor in its maximum period to prison correctional in its minimum period shall be imposed upon any person who, in order to require or enforce the payment of a debt, shall compel the debtor to work for him, against his will, as household servant or farm laborer. Chapter 2. Crimes against security. Section 1. Abandonment of helpless persons and exploitation of minors. Article 275. Abandonment of person in danger and abandonment of one's own victim. The penalty of arresto mayor shall be imposed upon 1. Anyone who shall fail to render assistance to any person whom he shall find in an uninhabited place wounded or in danger of dying, when he can render such assistance without detriment to himself, unless such omission shall constitute a more serious offense. 2. Anyone who shall fail to help or render assistance to another whom he is accidentally wounded or injured. 3. Anyone who, having found an abandoned child under 7 years of age, shall fail to deliver said child to the authorities or to his family, or shall fail to take him to a safe place. Article 276. Abandoning a minor. The penalty of arresto mayor and a fine not exceeding 500 pesos shall be imposed upon anyone who shall abandon a child under 7 years of age, the custody of which is incumbent upon him. When the death of the minor shall result from such abandonment, the culprit shall be punished by prison correctional in its medium and maximum periods, but if the life of the minor shall have been in danger only, the penalty shall be prison correctional in its minimum and medium periods. The provisions contained in the two preceding paragraphs shall not prevent the imposition of the penalty provided for the act committed, when the same shall constitute a more serious offense. Article 277. Abandonment of minor by person entrusted with his custody, indifference of parents. The penalty of arresto mayor and a fine not exceeding 500 pesos shall be imposed upon anyone who, having charge of the rearing or education of a minor, shall deliver said minor to a public institution or other persons, without the consent of the one who entrusted such child to his care or in the absence of the latter, without the consent of the proper authorities. The same penalty shall be imposed upon the parents who shall neglect their children by not giving them the education which their station in life require and financial conditions permit. Article 278. Exploitation of minors. The penalty of prison correctional in its minimum and medium periods and a fine not exceeding 500 pesos shall be imposed upon 1. Any person who shall cause any boy or girl under 16 years of age to perform any dangerous feat of balancing, physical strength, or contortion. 2. Any person who, being an acrobat, gymnast, rope walker, diver, wild animal tamer or circus manager or engaged in a similar calling, shall employ in exhibitions of these kinds children under 16 years of age who are not his children or descendants. 3. Any person engaged in any of the callings enumerated in the next paragraph preceding who shall employ any descendant of his under 12 years of age in such dangerous exhibitions. 4. Any ascendant, guardian, teacher or person entrusted in any capacity with the care of a child under 16 years of age, who shall deliver such child gratuitously to any person following any of the callings enumerated in paragraph 2 hereof, or to any habitual vagrant or beggar. If the delivery shall have been made in consideration of any price, compensation, or promise, the penalty shall in every case be imposed in its maximum period. In either case, the guardian or curator convicted shall also be removed from office as guardian or curator, and in the case of the parents of the child, they may be deprived, temporarily or perpetually, in the discretion of the court, of their parental authority. 5. Any person who shall induce any child under 16 years of age to abandon the home of its ascendants, guardians, curators, or teachers to follow any person engaged in any of the callings mentioned in paragraph 2 hereof, or to accompany any habitual vagrant or beggar. Article 279. Additional penalties for other offences. The imposition of the penalties prescribed in the preceding articles shall not prevent the imposition upon the same person of the penalty provided for any other felonies defined and punished by this code. Section 2. Trespass to dwelling. Article 280. Qualified trespass to dwelling. Any private person who shall enter the dwelling of another against the latter's will shall be punished by arrest au maire and a fine not exceeding 1,000 pesos. If the offense be committed by means of violence or intimidation, the penalty shall be prison correctional in its medium and maximum periods and a fine not exceeding 1,000 pesos. The provisions of this article shall not be applicable to any person who shall enter another's dwelling for the purpose of preventing some serious harm to himself, the occupants of the dwelling or a third person, nor shall it be applicable to any person who shall enter a dwelling for the purpose of rendering some service to humanity or justice, nor to anyone who shall enter cafes, taverns, inn and other public houses, while the same are open. Article 281. Other forms of trespass. The penalty of arrest au maire or a fine not exceeding 200 pesos, or both, shall be imposed upon any person who shall enter the closed premises or the fenced estate of another, while either or them are uninhabited, if the prohibition to enter be manifest and the trespasser has not secured the permission of the owner or the caretaker thereof. Section 3. Threats and coercion. Article 282. Grave threats. Any person who shall threaten another with the infliction upon the person, honor or property of the latter or of his family of any wrong amounting to a crime, shall suffer 1. The penalty next lower in degree than that prescribed by law for the crime be threatened to commit, if the offender shall have made the threat demanding money or imposing any other condition, even though not unlawful, and said offender shall have attained his purpose. If the offender shall not have attained his purpose, the penalty lower by 2 degrees shall be imposed. If the threat be made in writing or through a middleman, the penalty shall be imposed in its maximum period. 2. The penalty of arrest au maire and a fine not exceeding 500 pesos, if the threat shall not have been made subject to a condition. Article 283. Light threats. Any threat to commit a wrong not constituting a crime, made in the manner expressed in subdivision 1 of the next preceding article, shall be punished by arrest au maire. Article 284. Bond for good behavior. In all cases falling within the 2 next preceding articles, the person making the threats may also be required to give bail not to molest the person threatened, or if he shall fail to give such bail, he shall be sentenced to destierro. Article 285. Other light threats. The penalty of arrest au maire in its minimum period or a fine not exceeding 200 pesos shall be imposed upon 1. Any person who, without being included in the provisions of the next preceding article, shall threaten another with a weapon or draw such weapon in a quarrel, unless it be in lawful self-defense. 2. Any person who, in the heat of anger, shall orally threaten another with some harm not constituting a crime, and who by subsequent acts show that he did not persist in the idea involved in his threat, provided that the circumstances of the offense shall not bring it within the provisions of Article 282 of this Code. 3. Any person who shall orally threaten to do another any harm not constituting a felony. Article 286. Grave coercions. The penalty of arresto mayor and a fine not exceeding 500 pesos shall be imposed upon any person who, without authority of law, shall, by means of violence, prevent another from doing something not prohibited by law, or compel him to do something against his will, whether it be right or wrong. If the coercion be committed for the purpose of compelling another to perform any religious act or to prevent him from so doing, the penalty next higher in degree shall be imposed. Article 287. Light coercions. Any person who, by means of violence, shall seize anything belonging to his debtor for the purpose of applying the same to the payment of the debt, shall suffer the penalty of arresto mayor in its minimum period and a fine equivalent to the value of the thing, but in no case less than 75 pesos. Any other coercions or unjust vexations shall be punished by arresto mayor or a fine ranging from 5 pesos to 200 pesos, or both. Article 288. Other similar coercions. Compulsory purchase of merchandise and payment of wages by means of tokens. The penalty of arresto mayor or a fine ranging from 200 to 500 pesos, or both, shall be imposed upon any person, agent or officer, of any association or corporation who shall force or compel, directly or indirectly, or shall knowingly permit any laborer or employee employed by him or by such firm or corporation to be forced or compelled, to purchase merchandise or commodities of any kind. The same penalties shall be imposed upon any person who shall pay the wages due a laborer or employee employed by him, by means of tokens or objects other than the legal tender currency of the laborer or employee. Article 289. Formation, maintenance and prohibition of combination of capital or labor through violence or threats. The penalty of arresto mayor and a fine not exceeding 300 pesos shall be imposed upon any person who, for the purpose of organizing, maintaining or preventing coalitions or capital or labor, strike of laborers or lockout of employees, shall employ violence or threats in such a degree as to compel or force the laborers or employers in the free and legal exercise of their industry or work, if the act shall not constitute a more serious offense in accordance with the provisions of this Code. Chapter 3. Discovery and revelation of secrets. Article 290. Discovering secrets through seizure of correspondence. The penalty of prison correctional in its minimum and medium periods and a fine not exceeding 500 pesos shall be imposed upon any private individual who, in order to discover the secrets of another, shall seize his papers or letters and reveal the contents thereof. If the offender shall not reveal such secrets, the penalty shall be arresto mayor and a fine not exceeding 500 pesos. The provision shall not be applicable to parents, guardians, or persons entrusted with the custody of minors with respect to the papers or letters of the children or minors placed under their care or study, nor to spouses with respect to the papers or letters of either of them. Article 291. Revealing secrets with abuse of office. The penalty of arresto mayor and a fine not exceeding 500 pesos shall be imposed upon any manager, employee, or servant who, in such capacity, shall learn the secrets of his principal or master and shall reveal such secrets. Article 292. Revelation of industrial secrets. The penalty of prison correctional in its minimum and medium periods and a fine not exceeding 500 pesos shall be imposed upon the person in charge, employee or workman of any manufacturing or industrial establishment who, to the prejudice of the owner thereof, shall reveal the secrets of the industry of the latter. Title 10. Crimes against property. Chapter 1. Robbery in general. Article 293. Who are guilty of robbery. Any person who, with intent to gain, shall take any personal property belonging to another, by means of violence or intimidation of any person, or using force upon anything shall be guilty of robbery. Section 1. Robbery with violence or intimidation of persons. Article 295. Robbery with violence against or intimidation of persons. Penalties. Any person guilty of robbery with the use of violence against or intimidation of any person shall suffer 1. The penalty of reclusion perpetua to death, when by reason or on occasion of the robbery, the crime of homicide shall have been committed. 2. The penalty of reclusion temporal in its medium period to reclusion perpetua when the robbery shall have been accompanied by rape or intentional mutilation, or if by reason or on occasion of such robbery, any of the physical injuries penalized in subdivision 1 of Article 263 shall have been inflicted, provided, however, that when the robbery accompanied with rape is committed with the use of a deadly weapon or by 2 or more persons, the penalty shall be reclusion perpetua to death, as amended by PD No. 767. 3. The penalty of reclusion temporal, when by reason or on occasion of the robbery, any of the physical injuries penalized in subdivision 2 of the article mentioned in the next preceding paragraph, shall have been inflicted. 4. The penalty of prison mere in its maximum period to reclusion temporal in its medium period, if the violence or intimidation employed in the commission of the robbery shall have been carried to a degree clearly unnecessary for the commission of the crime, or when the course of its execution, the offender shall have inflicted upon any person not responsible for its commission any of the physical injuries covered by subdivisions 3 and 4 of said Article 23. 5. The penalty of prison correctional in its maximum period to prison mere in its medium period in other cases, as amended by R.A. 18. Article 295. Robbery with physical injuries, committed in an uninhabited place and by a band, or with the use of firearm on a street, road or alley. If the offences mentioned in subdivisions 3, 4, and 5 of the next preceding article shall have been committed in an uninhabited place or by a band, or by attacking a moving train, streetcar, motor vehicle or airship, or by entering the passengers' compartments in a train or, in any manner, taking the passengers thereof by surprise in their respective conveyances, or on a street, road, highway, or alley, and the intimidation is made with the use of a firearm, the offender shall be punished by the maximum period of the proper penalties. In the same cases, the penalty next higher in degree shall be imposed upon the leader of the band. Article 296. Definition of a band and penalty incurred by the members thereof. When more than 3 armed malefactors take part in the commission of a robbery, it shall be deemed to have been committed by a band. When any of the arms used in the commission of the offence be an unlicensed firearm, the penalty to be imposed upon all the malefactors shall be the maximum of the corresponding penalty provided by law, without prejudice of the criminal liability for illegal possession of such unlicensed firearms. Any member of a band who is present at the commission of a robbery by the band, shall be punished as principal of any of the assaults committed by the band, unless it be shown that he attempted to prevent the same. Article 297. Attempted and frustrated robbery committed under certain circumstances. When by reason or on occasion of an attempted or frustrated robbery a homicide is committed, the person guilty of such offences shall be punished by reclusion temporal in its maximum period to reclusion perpetua, unless the homicide committed shall deserve a higher penalty under the provisions of this code. Article 298. Execution of deeds by means of violence or intimidation. Any person who, with intent to defraud another, by means of violence or intimidation, shall compel him to sign, execute or deliver any public instrument or documents, shall be held guilty of robbery and punished by the penalties respectively prescribed in this chapter. Section 2. Robbery by the use of force upon things. Article 299. Robbery in an inhabited house or public building or edifice devoted to worship. Any armed person who shall commit robbery in an inhabited house or public building or edifice devoted to religious worship, shall be punished by reclusion temporal, if the value of the property taken shall exceed 250 pesos, and if a. the malefactors shall enter the house or building in which the robbery was committed, by any of the following means. 1. Through an opening not intended for entrance or egress. 2. By breaking any wall, roof, or floor or breaking any door or window. 3. By using false keys, picklocks or similar tools. 4. By using any fictitious name or pretending the exercise of public authority. Or if b. the robbery be committed under any of the following circumstances. 1. By the breaking of doors, wardrobes, chests, or any other kind of locked or sealed furniture or receptacle. 2. By taking such furniture or objects to be broken or forced open outside the place of the robbery. When the offenders do not carry arms, and the value of the property taken exceeds 250 pesos, the penalty next lower in degree shall be imposed. The same rule shall be applied when the offenders are armed, but the value of the property taken does not exceed 250 pesos. When said offenders do not carry arms and the value of the property taken does not exceed 250 pesos, they shall suffer the penalty prescribed in the two next preceding paragraphs, in its minimum period. If the robbery be committed in one of the dependencies of an inhabited house, public building, or building dedicated to religious worship, the penalties next lower in degree than those prescribed in this article shall be imposed. Article 300. Robbery in an uninhabited place and by a band. The robbery mentioned in the next preceding article, if committed in an uninhabited place and by a band, shall be punished by the maximum period of the penalty provided therefor. Article 301. What is an inhabited house, public building or building dedicated to religious worship and their dependencies? Inhabited house means any shelter, ship or vessel constituting the dwelling of one or more persons, even though the inhabitants thereof shall temporarily be absent therefrom when the robbery is committed. All interior courts, corrals, waterhouses, granaries, barns, coach houses, stables or other departments or enclosed places contiguous to the building or edifice, having an interior entrance connected therewith, and which form part of the whole, shall be deemed dependencies of an inhabited house, public building or building dedicated to religious worship. Orchards and other lands used for cultivation or production are not included in the terms of the next preceding paragraph, even if closed, contiguous to the building and having direct connection therewith. The term public building includes every building owned by the government or belonging to a private person not included used or rented by the government, although temporarily unoccupied by the same. Article 302. Robbery is an uninhabited place or in a private building. Any robbery committed in an uninhabited place or in a building other than those mentioned in the first paragraph of Article 299, if the value of the property taken exceeds 250 pesos, shall be punished by prison correctional if any of the following circumstances is present. 1. If the entrance has been effected through any opening not intended for entrance or egress. 2. If any wall, roof, flower or outside door or window has been broken. 3. If the entrance has been effected through the use of false keys, picklocks or other similar tools. 4. If any dorm, wardrobe, chest or by sealed or closed furniture or receptacle has been broken. 5. If any closed or sealed receptacle, as mentioned in the preceding paragraph, has been removed even if the same to broken open elsewhere. When the value of the property takes does not exceed 250 pesos, the penalty next lower in degree shall be imposed. In the cases specified in Articles 294, 295, 297, 299, 300, and 302 of this code, when the property taken is male matter or large cattle, the offender shall suffer the penalties next higher in degree than those provided in said articles. Article 303. Robbery of cereals, fruits, or firewood in an uninhabited place or private building. In the cases enumerated in Articles 299 and 302, when the robbery consists in the taking of cereals, fruits, or firewood, the culprit shall suffer the penalty next lower in degree than that prescribed in said articles. Article 304. Possession of picklocks or similar tools. Any person who shall without lawful cause have in his possession picklocks or similar tools especially adopted to the commission of the crime of robbery, shall be punished by arrest or mayor in its maximum period to prison correctional in its minimum period. The same penalty shall be imposed upon any person who shall make such tools. If the offender be a locksmith, he shall suffer the penalty of prison correctional in its medium and maximum periods. Article 305. False keys. The term false keys shall be deemed to include 1. The tools mentioned in the next preceding articles. 2. Genuine keys stolen from the owner. 3. Any keys other than those intended by the owner for use in the lock forcibly opened by the offender. Chapter 2. Brigandage. Article 306. Who are brigands? Penalty. When more than 3 armed persons form a band of robbers for the purpose of committing robbery in the highway, or kidnapping persons for the purpose of extortion or to obtain ransom or for any other purpose to be attained by means of force and violence, they shall be deemed highway robbers or brigands. Persons found guilty of this offense shall be punished by prison mayor in its medium period to reclusion temporal in its minimum period if the act or acts committed by them are not punishable by higher penalties, in which case, they shall suffer such high penalties. If any of the arms carried by any of said persons be an unlicensed firearms, it shall be presumed that said persons are highway robbers or brigands, and in case of convictions the penalty shall be imposed in the maximum period. Article 307. Aiding and abetting a band of brigands. Any person knowingly and in any manner aiding, abetting or protecting a band of brigands as described in the next preceding article, or giving them information of the movements of the police or other peace officers of the government, or of the forces of the United States Army, when the latter are acting in aid of the government, or acquiring or receiving the property taken by such brigands shall be punished by prison correctional in its medium period to prison mayor in its minimum period. It shall be presumed that the person performing any of the acts provided in this article has performed them knowingly, unless the contrary is proven. Chapter 3. Theft. Article 308. Who are liable for theft. Theft is committed by any person who, with intent to gain but without violence against or intimidation of persons nor force upon things, shall take personal property of another without the latter's consent. Theft is likewise committed by 1. Any person who, having found lost property, shall fail to deliver the same to the local authorities or to its owner. 2. Any person who, after having maliciously damaged the property of another, shall remove or make use of the fruits or object of the damage caused by him, and 3. Any person who shall enter an enclosed estate or a field where trespass is forbidden or which belongs to another and without the consent of its owner, shall hunt or fish upon the same or shall gather cereals, or other forest or farm products. Article 309. Penalties. Any person guilty of theft shall be punished by 1. The penalty of prison mayor in its minimum and medium periods, if the value of the thing stolen is more than 12,000 pesos but does not exceed 22,000 pesos, but if the value of the thing stolen exceeds the latter amount the penalty shall be the maximum period of the one prescribed in this paragraph, and 1 year for each additional 10,000 pesos, but the total of the penalty which may be imposed shall not exceed 20 years. In such cases, and in connection with the accessory penalties which may be imposed and for the purpose of the other provisions of this code, the penalty shall be termed prison mayor or reclusion temporal, as the case may be. 2. The penalty of prison correctional in its medium and maximum periods, if the value of the thing stolen is more than 6,000 pesos but does not exceed 12,000 pesos. 3. The penalty of prison correctional in its minimum and medium periods, if the value of the property stolen is more than 200 pesos but does not exceed 6,000 pesos. 4. Arresto mayor in its medium period to prison correctional in its minimum period, if the value of the property stolen is over 50 pesos but does not exceed 200 pesos. 5. Arresto mayor to its full extent, if such value is over 5 pesos but does not exceed 50 pesos. 6. Arresto mayor in its minimum and medium periods, if such value does not exceed 5 pesos. 7. Arresto menor or a fine not exceeding 200 pesos, if the theft is committed under the circumstances enumerated in paragraph 3 of the next preceding article and the value of the thing stolen does not exceed 5 pesos. If such value exceeds said amount, the provision of any of the 5 preceding subdivisions shall be made applicable. 8. Arresto menor in its minimum period or a fine not exceeding 50 pesos, when the value of the thing stolen is not over 5 pesos, and the offender shall have acted under the impulse of hunger, poverty, or the difficulty of earning a livelihood for the support of himself or his family. Article 310. Qualified theft. The crime of theft shall be punished by the penalties next higher by 2 degrees than those respectively specified in the next preceding article, if committed by a domestic servant, or with grave abuse of confidence, or if the property stolen is motor vehicle, mail matter or large cattle or consists of coconuts taken from the premises of the plantation or fish taken from a fish pond or fishery, or if property is taken on the occasion of fire, earthquake, typhoon, volcanic eruption, or any other calamity, vehicular accident or civil disturbance. As amended by Republic Act 120 and BP by Lang 71. May 1, 1980. Article 311. Theft of the property of the National Library and National Museum. If the property stolen be any property of the National Library or the National Museum, the penalty shall be arresto mayor or a fine ranging from 200 to 500 pesos, or both, unless a higher penalty should be provided under other provisions of this code, in which case, the offender shall be punished by such higher penalty. Chapter 4. Usurpation. Article 312. Occupation of real property or usurpation of real rights in property. Any person who, by means of violence against or intimidation of persons, shall take possession of any real property or shall usurp any real rights in property belonging to another, in addition to the penalty incurred for the acts of violence executed by him, shall be punished by a fine from 50 to 100% of the gain which he shall have obtained, but not less than 75 pesos. If the value of the gain cannot be ascertained, a fine of from 200 to 500 pesos shall be imposed. Article 313. Altering boundaries or landmarks. Any person who shall alter the boundary marks or monuments of towns, provinces, or estates, or any other marks intended to designate the boundaries of the same, shall be punished by arresto menor or a fine not exceeding 100 pesos, or both. Chapter 5. Culpable insolvency. Article 314. Fraudulent insolvency. Any person who shall abscond with his property to the prejudice of his creditors, shall suffer the penalty of prison mayor, if he be a merchant, and the penalty of prison correctional in its maximum period to prison mayor in its medium period, if he be not a merchant. Chapter 6. Swindling and other deceits. Article 315. Swindling, estafa. Any person who shall defraud another by any of the means mentioned here and below shall be punished by: first, the penalty of prison correctional in its maximum period to prison mayor in its minimum period, if the amount of the fraud is over 12,000 pesos but does not exceed 22,000 pesos, and if such amount exceeds the latter sum, the penalty provided in this paragraph shall be imposed in its maximum period, adding 1 year for each additional 10,000 pesos, but the total penalty which may be imposed shall not exceed 20 years. In such cases, and in connection with the accessory penalties which may be imposed under the provisions of this code, the penalty shall be termed prison mere or reclusion temporal, as the case may be. Second, the penalty of prison correctional in its minimum and medium periods, if the amount of the fraud is over 6,000 pesos but does not exceed 12,000 pesos. Third, the penalty of arresto mere in its maximum period to prison correctional in its minimum period if such amount is over 200 pesos but does not exceed 6,000 pesos, and fourth, by arresto mere in its maximum period, if such amount does not exceed 200 pesos, provided that in the 4 cases mentioned, the fraud be committed by any of the following means. 1. With unfaithfulness or abuse of confidence, namely, a. By altering the substance, quantity, or quality or anything of value which the offender shall deliver by virtue of an obligation to do so, even though such obligation be based on an immoral or illegal consideration. B. By misappropriating or converting, to the prejudice of another, money, goods, or any other personal property received by the offender in trust or on commission, or for administration, or under any other obligation involving the duty to make delivery of or to return the same, even though such obligation be totally or partially guaranteed by a bond, or by denying having received such money, goods, or other property. C. By taking undue advantage of the signature of the offended party in blank, and by writing any document above such signature in blank, to the prejudice of the offended party or of any third person. 2. By means of any of the following false pretenses or fraudulent acts executed prior to or simultaneously with the commission of the fraud. A. By using fictitious name, or falsely pretending to possess power, influence, qualifications, property, credit, agency, business or imaginary transactions, or by means of other similar deceits. B. By altering the quality, fineness or weight of anything pertaining to his art or business. C. By pretending to have bribed any government employee, without prejudice to the action for calumny which the offended party may deem proper to bring against the offender. In this case, the offender shall be punished by the maximum period of the penalty. D. By post-dating a check, or issuing a check in payment of an obligation when the offender therein were not sufficient to cover the amount of the check. The failure of the drawer of the check to deposit the amount necessary to cover his check within 3 days from receipt of notice from the bank and/or the payee or holder that said check has been dishonored for lack of insufficiency of funds shall be prima facie evidence of deceit constituting false pretense or fraudulent act. As amended by Republic Act 4885, approved June 17, 1967. E. By obtaining any food, refreshment or accommodation at a hotel, inn, restaurant, boarding house, lodging house, or apartment house and the like without paying therefor, with intent to defraud the proprietor or manager thereof, or by obtaining credit at hotel, inn, restaurant, boarding house, lodging house, or apartment house by the use of any false pretense, or by abandoning or surreptitiously removing any part of his baggage from a hotel, inn, restaurant, boarding house, lodging house or apartment house after obtaining credit, food, refreshment or accommodation therein without paying for his food, refreshment or accommodation. 3. Through any of the following fraudulent means. A. By inducing another, by means of deceit, to sign any document. B. By resorting to some fraudulent practice to ensure success in a gambling game. C. By removing, concealing or destroying, in whole or in part, any court record, office files, document or any other papers. Article 316. Other forms of swindling. the penalty of arresto mare in its minimum and medium period and a fine of not less than the value of the damage caused and not more than 3 times such value, shall be imposed upon 1. Any person who, pretending to be owner of any real property, shall convey, sell, encumber or mortgage the same. 2. Any person who, knowing that real property is encumbered, shall dispose of the same, although such encumbrance be not recorded. 3. The owner of any personal property who shall wrongfully take it from its lawful possessor, to the prejudice of the latter or any third person. 4. Any person who, to the prejudice of another, shall execute any fictitious contract. 5. Any person who shall accept any compensation given him under the belief that it was in payment of services rendered or labor performed by him, when in fact he did not actually perform such services or labor. 6. Any person who, while being a surety in a bond given in a criminal or civil action, without express authority from the court or before the cancellation of his bond or before being relieved from the obligation contracted by him, shall sell, mortgage, or, in any other manner, encumber the real property or properties with which he guaranteed the fulfillment of such obligation. Article 317. Swindling a minor. Any person who, taking advantage of the inexperience or emotions or feelings of a minor, to his detriment, shall induce him to assume any obligation or to give any release or execute a transfer of any property right in consideration of some loan of money, credit or other personal property, whether the loan clearly appears in the document or is shown in any other form, shall suffer the penalty of arresto mare and a fine of a sum ranging from 10 to 50% of the value of the obligation contracted by the minor. Article 318. Other deceits. The penalty of arresto mare and a fine of not less than the amount of the damage caused and not more than twice such amount shall be imposed upon any person who shall defraud or damage another by any other deceit not mentioned in the preceding articles of this chapter. Any person who, for profit or gain, shall interpret dreams, make forecasts, tell fortunes, or take advantage of the credulity of the public in any other similar manner, shall suffer the penalty of arresto mare or a fine not exceeding 200 pesos. Chapter 7. Chattel Mortgage. Article 319. Removal, sale or pledge of mortgaged property. The penalty or arresto mare or a fine amounting to twice the value of the property shall be imposed upon 1. Any person who shall knowingly remove any personal property mortgaged under the chattel mortgage law to any province or city other than the one in which it was located at the time of the execution of the mortgage, without the written consent of the mortgagee, or his executors, administrators or assigns. 2. Any mortgagor who shall sell or pledge personal property already pledged, or any part thereof, under the terms of the chattel mortgage law, without the consent of the mortgagee written on the back of the mortgage and noted on the records hereof in the office of the Register of Deeds of the province where such property is located. Chapter 8. Arson and other crimes involving destructions. Article 320. Destructive arson. The penalty of reclusion temporal in its maximum period to reclusion perpetua shall be imposed upon any person who shall burn 1. Any arsenal, shipyard, storehouse or military powder or fireworks factory, ordnance, storehouse, archives or general museum of the government. 2. Any passenger train or motor vehicle in motion or vessel out of port. 3. In an inhabited place, any storehouse or factory of inflammable or explosive materials. Article 321. Other forms of arson. When the arson consists in the burning of other property and under the circumstances given hereunder, the offender shall be punishable. 1. By reclusion temporal or reclusion perpetua. A. If the offender shall set fire to any building, farmhouse, warehouse, hut, shelter, or vessel in port, knowing it to be occupied at the time by one or more persons. B. If the building burned is a public building and value of the damage caused exceeds 6,000 pesos. C. if the building burned is a public building and the purpose is to destroy evidence kept therein to be used in instituting prosecution for the punishment of violators of the law, irrespective of the amount of the damage. D. If the building burned is a public building and the purpose is to destroy evidence kept therein to be used in legislative, judicial or administrative proceedings, irrespective of the amount of the damage, provided, however, that if the evidence destroyed is to be used against the defendant for the prosecution of any crime punishable under existing laws, the penalty shall be reclusion perpetua. E. If the arson shall have been committed with the intention of collecting under an insurance policy against loss or damage by fire. 2. By reclusion temporal. A. If an inhabited house or any other building in which people are accustomed to meet is set on fire, and the culprit did not know that such house or building was occupied at the time, or if he shall set fire to a moving freight train or motor vehicle, and the value of the damage caused exceeds 6,000 pesos. B. If the value of the damage caused in paragraph B of the preceding subdivision does not exceed 6,000 pesos. C. If a farm, sugar mill, cane mill, mill central, bamboo groves or any similar plantation is set on fire and the damage caused exceeds 6,000 pesos, and D. If grain fields, pasture lands, or forests, or plantings are set on fire, and the damage caused exceeds 6,000 pesos. 3. By prison mayor. A. If the value of the damage caused in the case mentioned in paragraphs A, C, and D, in the next preceding subdivision does not exceed 6,000 pesos. B. If a building not used as a dwelling or place of assembly, located in a populated place, is set on fire, and the damage caused exceeds 6,000 pesos. 4. By prison correctional in its maximum period to prison mayor in its medium period. A. If a building used as dwelling located in an uninhabited place is set on fire and the damage caused exceeds 1,000 pesos. B. If the value or the damage caused in the case mentioned in paragraphs C and D of subdivision 2 of this article does not exceed 200 pesos. 5. By prison correctional in its medium period to prison mayor in its minimum period, when the damage caused is over 200 pesos but does not exceed 1,000 pesos, and the property referred to in paragraph A of the preceding subdivision is set on fire, but when the value of such property does not exceed 200 pesos, the penalty next lower in degree than that prescribed in this subdivision shall be imposed. 6. The penalty of prison correctional in its medium and maximum periods, if the damage caused in the case mentioned in paragraph B of subdivision 3 of this article does not exceed 6,000 pesos but is over 200 pesos. 7. The penalty of prison correctional in its minimum and medium periods, if the damage caused in the case mentioned paragraph B, subdivision 3 of this article does not exceed 200 pesos. 8. The penalty of arresto mayor and a fine ranging from 50 to 100% if the damage caused shall be imposed, when the property burned consists of grain fields, pasture lands, forests, or plantations when the value of such property does not exceed 200 pesos. As amended by Republic Act 5467, approved May 12, 1969. Article 322. Cases of arson not included in the preceding articles. Cases of arson not included in the next preceding articles shall be punished. 1. By arresto mayor in its medium and maximum periods, when the damage caused does not exceed 50 pesos. 2. By arresto mayor in its maximum period to prison correctional in its minimum period, when the damage caused is over 50 pesos but does not exceed 200 pesos. 3. By prison correctional in its minimum and medium periods, if the damage caused is over 200 pesos but does not exceed 1,000 pesos, and 4. By prison correctional in its medium and maximum periods, if it is over 1,000 pesos. Article 323. Arson of property of small value. The arson of any uninhabited hut, storehouse, barn, shed, or any other property the value of which does not exceed 25 pesos, committed at a time or under circumstances which clearly exclude all danger of the fire spreading, shall not be punished by the penalties respectively prescribed in this chapter, but in accordance with the damage caused and under the provisions of the following chapter. Article 324. Crimes involving destruction. Any person who shall cause destruction by means of explosion, discharge of electric current, inundation, sinking or stranding of a vessel, intentional damaging of the engine of said vessel, taking up the rails from a railway track, maliciously changing railway signals for the safety of moving trains, destroying telegraph wires and telegraph posts, or those of any other system, and, in general, by using any other agency or means of destruction as effective as those above enumerated, shall be punished by reclusion temporarily if the commission has endangered the safety of any person; otherwise, the penalty of prison shall be imposed. Article 325. Burning one's own property as means to commit arson. Any person guilty of arson or causing great destruction of the property belonging to another shall suffer the penalties prescribed in this chapter, even though he shall have set fire to or destroyed his own property for the purposes of committing the crime. Article 326. Setting fire to property exclusively owned by the offender. If the property burned shall be the exclusive property of the offender, he shall be punished by arresto mayor in its maximum period to prison correctional in its minimum period. If the arson shall have been committed for the purpose of defrauding or causing damage to another, or prejudice shall actually have been caused, or if the thing burned shall have been a building in an inhabited place. Article 326a. In cases where death resulted as a consequence of arson. If death resulted as a consequence of arson committed on any of the properties and under any of the circumstances mentioned in the preceding articles, the court shall impose the death penalty. Article 326b. Prima facie evidence of arson. Any of the following circumstances shall constitute prima facie evidence of arson. 1. If after the fire are found materials or substances soaked in gasoline, kerosene, petroleum, or other inflammables, or any mechanical, electrical, chemical or traces or any of the foregoing. 2. That substantial amount of inflammable substance or materials were stored within the building not necessary in the course of the defendant's business, and 3. That the fire started simultaneously in more than one part of the building or locale under circumstances that cannot normally be due to accidental or unintentional causes, provided, however, that at least one of the following is present in any of the three above-mentioned circumstances. A. That the total insurance carried on the building and or goods is more than 80% of the value of such building and or goods at the time of the fire. B. That the defendant after the fire has presented a fraudulent claim for loss. The penalty of prison correctional shall be imposed on one who plants the articles above mentioned, in order to secure a conviction, or as a means of extortion or coercion. As amended by Republic Act 5467. Approved May 12, 1969. Click here for the full text of Presidential Decree No. 1613. Amending the Law on Arson. Click here for the full text of Presidential Decree No. 1744. Amending Article 320 of the Revised Penal Code Provisions on Arson. Chapter 9. Malicious Mischief. Article 327. Who are liable for malicious mischief. Any person who shall deliberately cause the property of another any damage not falling within the terms of the next preceding chapter shall be guilty of malicious mischief. Article 328. Special cases of malicious mischief. Any person who shall cause damage to obstruct the performance of public functions, or using any poisonous or corrosive substance, or spreading any infection or contagion among cattle, or who cause damage to the property of the National Museum or National Library, or to any archive or registry, waterworks, road, promenade, or any other thing used in common by the public, shall be punished. 1. By prison correctional in its minimum and medium periods, if the value of the damage caused exceeds 1,000 pesos. 2. By arresto mea, if such value does not exceed the above-mentioned amount but it is over 200 pesos, and 3. By arresto menor, in such value does not exceed 200 pesos. Article 329. Other mischiefs. The mischiefs not included in the next preceding article shall be punished. 1. By arresto mea in its medium and maximum periods, if the value of the damage caused exceeds 1,000 pesos. 2. By arresto mea in its minimum and medium periods, if such value is over 200 pesos but does not exceed 1,000 pesos, and 3. By arresto menor or fine of not less than the value of the damage caused and not more than 200 pesos, if the amount involved does not exceed 200 pesos or cannot be estimated. Article 330. Damage and obstruction to means of communication. The penalty of prison correctional in its medium and maximum periods shall be imposed upon any person who shall damage any railway, telegraph or telephone lines. If the damage shall result in any derailment of cars, collision or other accident, the penalty of prison mea shall be imposed, without prejudice to the criminal liability of the offender for the other consequences of his criminal act. For the purpose of the provisions of the article, the electric wires, traction cables, signal system and other things pertaining to railways, shall be deemed to constitute an integral part of a railway system. Article 331. Destroying or damaging statues, public monuments or paintings. Any person who shall destroy or damage statues or any other useful or ornamental public monument shall suffer the penalty of arresto mea in its medium period to prison correctional in its minimum period. Any person who shall destroy or damage any useful or ornamental painting of a public nature shall suffer the penalty of arresto menor or a fine not exceeding 200 pesos, or both such fine and imprisonment, in the discretion of the court. Chapter 10. Exemption from criminal liability. In crimes against property. Article 332. Persons exempt from criminal liability. No criminal, but only civil liability, shall result from the commission of the crime of theft, swindling or malicious mischief committed or caused mutually by the following persons. 1. Spouses, ascendants and descendants, or relatives by affinity in the same line. 2. The widowed spouse with respect to the property which belonged to the deceased spouse before the same shall have passed into the possession of another, and 3. Brothers and brothers-in-law and sisters-in-law, if living together. The exemption established by this article shall not be applicable to strangers participating in the commission of the crime. Title 11. Crimes against chastity. Chapter 1. Adultery and concubinage. Article 333. Who are guilty of adultery. Adultery is committed by any married woman who shall have sexual intercourse with a man not her husband and by the man who has carnal knowledge of her knowing her to be married, even if the marriage be subsequently declared void. Adultery shall be punished by prison correctional in its medium and maximum periods. If the person guilty of adultery committed this offense while being abandoned without justification by the offended spouse, the penalty next lower in degree than that provided in the next preceding paragraph shall be imposed. Article 334. Concubinage. Any husband who shall keep a mistress in the conjugal dwelling, or shall have sexual intercourse, under scandalous circumstances, with a woman who is not his wife, or shall cohabit with her in any other place, shall be punished by prison correctional in its minimum and medium periods. The concubine shall suffer the penalty of destierro. Chapter 2. Rape and acts of lasciviousness. Article 335. When and how rape is committed. Rape is committed by having carnal knowledge of a woman under any of the following circumstances. 1. By using force or intimidation. 2. When the woman is deprived of reason or otherwise unconscious, and 3. when the woman is under 12 years of age, even though neither of the circumstances mentioned in the two next preceding paragraphs shall be present. The crime of rape shall be punished by reclusion perpetua. Whenever the crime of rape is committed with the use of a deadly weapon or by two or more persons, the penalty shall be reclusion perpetua to death. When by reason or on the occasion of the rape, the victim has become insane, the penalty shall be death. When rape is attempted or frustrated and a homicide is committed by reason or on the occasion thereof, the penalty shall be likewise death. When by reason or on the occasion of the rape, a homicide is committed, the penalty shall be death. As amended by Republic Act 2632, approved June 18, 1960, and Republic Act 4111, approved June 20, 1964. Article 336. Acts of lasciviousness. Any person who shall commit any act of lasciviousness upon other persons of either sex, under any of the circumstances mentioned in the preceding article, shall be punished by prison correctional. Chapter 3. Seduction, corruption of minors, and white slave trade. Article 337. Qualified seduction. The seduction of a virgin over 12 years and under 18 years of age, committed by any person in public authority, priest, home servant, domestic, guardian, teacher, or any person who, in any capacity, shall be entrusted with the education or custody of the woman seduced, shall be punished by prison correctional in its minimum and medium periods. The penalty next higher in degree shall be imposed upon any person who shall seduce his sister or descendant, whether or not she be a virgin or over 18 years of age. Under the provisions of this chapter, seduction is committed when the offender has carnal knowledge of any of the persons and under the circumstances described herein. Article 338. Simple seduction. The seduction of a woman who is single or a widow of good reputation, over 12 but under 18 years of age, committed by means of deceit, shall be punished by arresto mea. Article 339. Acts of lasciviousness with the consent of the offended party. The penalty of arresto mea shall be imposed to punish any other acts of lasciviousness committed by the same persons and the same circumstances as those provided in Articles 337 and 338. Article 340. Corruption of minors. Any person who shall promote or facilitate the prostitution or corruption of persons under age to satisfy the lust of another, shall be punished by prison mea, and if the culprit is a public officer or employee, including those in government-owned or controlled corporations, he shall also suffer the penalty of temporary absolute disqualification. As amended by Batas Pambanza Bylaw 92. Article 341. White slave trade. The penalty of prison mea in its medium and maximum period shall be imposed upon any person who, in any manner, or under any pretext, shall engage in the business or shall profit by prostitution or shall enlist the services of any other for the purpose of prostitution, as amended by Batas Pambanza Bylaw 186. Chapter 4. Abduction. Article 342. Forcible abduction. The abduction of any woman against her will and with lewd designs shall be punished by reclusion temporal. The same penalty shall be imposed in every case, if the female abducted be under 12 years of age. Article 343. Consented abduction. The abduction of a virgin over 12 years and under 18 years of age, carried out with her consent and with lewd designs, shall be punished by the penalty of prison correctional in its minimum and medium periods. Chapter 5. Provisions relative to the preceding chapters of Title 11. Article 344. Prosecution of the crimes of adultery, concubinage, seduction, abduction, rape and acts of lasciviousness. The crimes of adultery and concubinage shall not be prosecuted except upon a complaint filed by the offended spouse. The offended party cannot institute criminal prosecution without including both the guilty parties, if they are both alive, nor, in any case, if he shall have consented or pardoned the offenders. The offences of seduction, abduction, rape or acts of lasciviousness, shall not be prosecuted except upon a complaint filed by the offended party or her parents, grandparents, or guardian, nor, in any case, if the offender has been expressly pardoned by the above-named persons, as the case may be. In cases of seduction, abduction, acts of lasciviousness and rape, the marriage of the offender with the offended party shall extinguish the criminal action or remit the penalty already imposed upon him. The provisions of this paragraph shall also be applicable to the co-principals, accomplices and accessories after the fact of the above-mentioned crimes. Article 345. Civil liability of persons guilty of crimes against chastity. Person guilty of rape, seduction or abduction, shall also be sentenced. 1. To indemnify the offended woman. 2. To acknowledge the offspring, unless the law should prevent him from so doing. 3. In every case to support the offspring. The adulterer and the concubine in the case provided for in Articles 333 and 334 may also be sentenced, in the same proceeding or in a separate civil proceeding, to indemnify for damages caused to the offended spouse. Article 346. Liability of ascendants, guardians, teachers, or other persons entrusted with the custody of the offended party. The ascendants, guardians, curators, teachers and any person who, by abuse of authority or confidential relationships, shall cooperate as accomplices in the perpetration of the crimes embraced in chapters 2nd, 3rd and 4th, of this title, shall be punished as principals. Teachers or other persons in any other capacity entrusted with the education and guidance of youth, shall also suffer the penalty of temporary special disqualification in its maximum period to perpetual special disqualification. Any person falling within the terms of this article, and any other person guilty of corruption of minors for the benefit of another, shall be punished by special disqualification from filling the office of guardian. Title 12. Crimes against the civil status of persons. Chapter 1. Simulation of births and usurpation of civil status. Article 347. Simulation of births, substitution of one child for another and concealment or abandonment of a legitimate child. The simulation of births and the substitution of one child for another shall be punished by prison mere and a fine of not exceeding 1,000 pesos. The same penalties shall be imposed upon any person who shall conceal or abandon any legitimate child with intent to cause such child to lose its civil status. Any physician or surgeon or public officer who, in violation of the duties of his profession or office, shall cooperate in the execution of any of the crimes mentioned in the two next preceding paragraphs, shall suffer the penalties therein prescribed and also the penalty of temporary special disqualification. Article 348. Usurpation of civil status. The penalty of prison mere shall be imposed upon any person who shall usurp the civil status of another, should he do so for the purpose of defrauding the offended part or his heirs. Otherwise, the penalty of prison correctional in its medium and maximum periods shall be imposed. Chapter 2. Illegal marriages. Article 349. Bigamy. The penalty of prison mere shall be imposed upon any person who shall contract a second or subsequent marriage before the former marriage has been legally dissolved, or before the absent spouse has been declared presumptively dead by means of a judgment rendered in the proper proceedings. Article 350. Marriage contracted against provisions of laws. The penalty of prison correctional in its medium and maximum periods shall be imposed upon any person who, without being included in the provisions of the next preceding article, shall have not been complied with or that the marriage is in disregard of a legal impediment. If either of the contracting parties shall obtain the consent of the other by means of violence, intimidation or fraud, he shall be punished by the maximum period of the penalty provided in the next preceding paragraph. Article 351. Premature marriages. Any widow who shall marry within 301 days from the date of the death of her husband, or before having delivered if she shall have been pregnant at the time of his death, shall be punished by arrest au maire and a fine not exceeding 500 pesos. The same penalties shall be imposed upon any woman whose marriage shall have been annulled or dissolved, if she shall marry before her delivery or before the expiration of the period of 301 days after the legal separation. Article 352. Performance of a legal marriage ceremony. Priests or ministers of any religious denomination or sect, or civil authorities who shall perform or authorize any legal marriage ceremony shall be punished in accordance with the provisions of the marriage law. Title 13. Crimes against Honor. Chapter 1. Libel. Section 1. Definitions, forms, and punishment of this crime. Article 353. Definition of libel. A libel is public and malicious imputation of a crime, or of a vice or defect, real or imaginary, or any act, omission, condition, status, or circumstance tending to cause the dishonor, discredit, or contempt of a natural or juridical person, or to blacken the memory of one who is dead. Article 354. Requirement for publicity. Every defamatory imputation is presumed to be malicious, even if it be true, if no good intention and justifiable motive for making it is shown, except in the following cases. 1. A private communication made by any person to another in the performance of any legal, moral or social duty, and 2. A fair and true report, made in good faith, without any comments or remarks, of any judicial, legislative or other official proceedings which are not of confidential nature, or of any statement, report or speech delivered in said proceedings, or of any other act performed by public officers in the exercise of their functions. Article 355. Libel means by writings or similar means. A libel committed by means of writing, printing, lithography, engraving, radio, phonograph, painting, theatrical exhibition, cinematographic exhibition, or any similar means, shall be punished by prison correctional in its minimum and medium periods or a fine ranging from 200 to 6,000 pesos, or both, in addition to the civil action which may be brought by the offended party. Article 356. Threatening to publish and offer to present such publication for a compensation. The penalty of arrest au maire or a fine from 200 to 2,000 pesos, or both, shall be imposed upon any person who threatens another to publish a libel concerning him or the parents, spouse, child, or other members of the family of the latter, or upon anyone who shall offer to prevent the publication of such libel for a compensation or money consideration. Article 357. Prohibited publication of acts referred to in the course of official proceedings. The penalty of arrest au maire or a fine of from 20 to 2,000 pesos, or both, shall be imposed upon any reporter, editor or manager or a newspaper, daily or magazine, who shall publish facts connected with the private life of another and offensive to the honor, virtue and reputation of said person, even though said publication be made in connection with or under the pretext that it is necessary in the narration of any judicial or administrative proceedings wherein such facts have been mentioned. Article 358. Slander. Oral defamation shall be punished by arrest au maire in its maximum period to prison correctional in its minimum period if it is of a serious and insulting nature. Otherwise the penalty shall be arrest au maire or a fine not exceeding 200 pesos. Article 359. Slander by deed. The penalty of arrest au maire in its maximum period to prison correctional in its minimum period or a fine ranging from 200 to 1,000 pesos shall be imposed upon any person who shall perform any act not included and punished in this title, which shall cast dishonor, discredit or contempt upon another person. If said act is not of a serious nature, the penalty shall be arrest au maire or a fine not exceeding 200 pesos. Section 2. General Provisions. Article 360. Persons responsible. Any person who shall publish, exhibit, or cause the publication or exhibition of any defamation in writing or by similar means, shall be responsible for the same. The author or editor of a book or pamphlet, or the editor or business manager of a daily newspaper, magazine or serial publication, shall be responsible for the defamations contained therein to the same extent as if he were the author thereof. The criminal and civil action for damages in cases of written defamations as provided for in this chapter, shall be filed simultaneously or separately with the court of first instance of the province or city where the libelous article is printed and first published, or where any of the offended parties actually resides at the time of the commission of the offense, provided, however, that where one of the offended parties is a public officer whose office is in the city of Manila at the time of the commission of the offense, the action shall be filed in the court of first instance of the city of Manila, or of the city or province where the libelous article is printed and first published, and in case such public officer does not hold office in the city of Manila, the action shall be filed in the court of first instance of the province or city where he held office at the time of the commission of the offense, or where the libelous article is printed and first published, and in case one of the offended parties is a private individual, the action shall be filed in the court of first instance of the province or city where he actually resides at the time of the commission of the offense, or where the libelous matter is printed and first published, provided, further, that the civil action shall be filed in the same court where the criminal action is filed, and vice versa, provided, furthermore, that the court where the criminal action or civil action for damages is first filed, shall acquire jurisdiction to the exclusion of other courts, and, provided, finally, that this amendment shall not apply to cases of written defamations, the civil and or criminal actions which have been filed in court at the time of the effectivity of this law. Preliminary investigation of criminal action for written defamations as provided for in the chapter shall be conducted by the provincial or city fiscal of the province or city, or by the municipal court of the city or capital of the province where such action may be instituted in accordance with the provisions of this article. No criminal action for defamation which consists in the imputation of a crime which cannot be prosecuted de officio shall be brought except at the instance of and upon complaint expressly filed by the offended party. As amended by Republic Act 1289, approved June 15, 1955, Republic Act 4363, approved June 19, 1965. Article 361. Proof of the truth. In every criminal prosecution for libel, the truth may be given in evidence to the court, and if it appears that the matter charged as libelous is true, and, moreover, that it was published with good motives and for justifiable ends, the defendants shall be acquitted. Proof of the truth of an imputation of an act or omission not constituting a crime shall not be admitted, unless the imputation shall have been made against government employees with respect to facts related to the discharge of their official duties. In such cases, if the defendant proves the truth of the imputation made by him, he shall be acquitted. Article 362. Libelous remarks. Libelous remarks or comments connected with the matter privileged under the provisions of Article 354, if made with malice, shall not exempt the author thereof nor the editor or managing editor of a newspaper from criminal liability. Chapter 2. Incriminatory machinations. Article 363. Incriminating innocent person. Any person who, by any act not constituting perjury, shall directly incriminate or impute to an innocent person the commission of a crime, shall be punished by arresto mena. Article 364. Intriguing against honor. The penalty of arresto mena or fine not exceeding 200 pesos shall be imposed for any intrigue which has for its principal purpose to blemish the honor or reputation of a person. Title 14. Quasi-offences. Sole Chapter. Criminal negligence. Article 365. Imprudence and negligence. Any person who, by reckless imprudence, shall commit any act which, had it been intentional, would constitute a grave felony, shall suffer the penalty of arrest au maire in its maximum period to prison correctional in its medium period. If it would have constituted a less grave felony, the penalty of arrest au maire in its minimum and medium periods shall be imposed. If it would have constituted a light felony, the penalty of arrest au maire in its maximum period shall be imposed. Any person who, by simple imprudence or negligence, shall commit an act which would otherwise constitute a grave felony, shall suffer the penalty of arrest au maire in its medium and maximum periods. If it would have constituted a less serious felony, the penalty of arrest au maire in its minimum period shall be imposed. When the execution of the act covered by this article shall have only resulted in damage to the property of another, the offender shall be punished by a fine ranging from an amount equal to the value of said damages to 3 times such value, but which shall in no case be less than 25 pesos. A fine not exceeding 200 pesos and censure shall be imposed upon any person who, by simple imprudence or negligence, shall cause some wrong which, if done maliciously, would have constituted a light felony. In the imposition of these penalties, the court shall exercise their sound discretion, without regard to the rules prescribed in Article 64. The provisions contained in this article shall not be applicable. 1. When the penalty provided for the offense is equal to or lower than those provided in the first 2 paragraphs of this article, in which case the court shall impose the penalty next lower in degree than that which should be imposed in the period which they may deem proper to apply. 2. When, by imprudence or negligence and with violation of the automobile law, to death of a person shall be caused, in which case the defendant shall be punished by prison correctional in its medium and maximum periods. Reckless imprudence consists in voluntary, but without malice, doing or falling to do an act from which material damage results by reason of inexcusable lack of precaution on the part of the person performing or failing to perform such act, taking into consideration his employment or occupation, degree of intelligence, physical condition and other circumstances regarding persons, time and place. Simple imprudence consists in the lack of precaution displayed in those cases in which the damage impending to be caused is not immediate nor the danger clearly manifest. The penalty next higher in degree to those provided for in this article shall be imposed upon the offender who fails to lend on the spot to the injured parties such help as may be in this hand to give. As amended by Republic Act 1790, approved June 21, 1957. Final provisions. Article 366. Application of laws enacted prior to this code. Without prejudice to the provisions contained in Article 22 of this code, felonies and misdemeanors, committed prior to the date of effectiveness of this code shall be punished in accordance with the code or acts in force at the time of their commission. Article 367. Repealing clause. Except as is provided in the next preceding article, the present Penal Code, the provisional law for the application of its provisions, and Acts Nos. 277, 282, 480, 518, 519, 899, 1121, 1438, 1523, 1559, 1692, 1754, 1955, 1773, 2020, 2036, 2071, 2142, 2212, 2293, 2298, 2300, 2364, 2549, 2557, 2595, 2609, 2718, 3103, 3195, 3244, 3298, 3309, 3313, 3397, 3559, and 3586 are hereby repealed. The provisions of the acts which are mentioned hereunder are also repealed, namely, Act 666, Sections 6 and 18. Act 1508, Sections 9, 10, 11, and 12. Act 1524, Sections 1, 2, and 6. Act 1697, Sections 3 and 4. Act 1757, Sections 1, 2, 3, 4, 5, 6, 7, First Clause, 11, and 12. Act 2381, Sections 2, 3, 4, 6, 8, and 9. Act 2711, Sections 102, 2670, 2671, and 2672. Act 3247, Sections 1, 2, 3, and 5, and General Order, No. 58, Series of 1900, Section 106. And all laws and parts of laws which are contrary to the provisions of this code are hereby repealed. Approved, December 8, 1930. Title of Acts repealed by the Revised Penal Code are 1. Act No. 277. Law on Libel and Threats to Publish Libel, etc., now provided for in Articles 353, 362. 2. Act No. 292, amended by Act No. 1692. Law defining and penalizing the crimes of treason, insurrection, sedition, etc., now provided for in Articles 114, 116 and Arts 134, 142. 3. Act No. 480. Law governing cockfighting and cockpits, now governed by Article 199 and special laws. 4. Act No. 518, amended by Act Nos. 1121 and 2036. Law defining and penalizing highway robbery or brigandage, now covered by Articles 306, 307. 5. Act No. 519. Law on vagrancy, now penalized by Article 202. 6. Act No. 666, Sections 6 and 18. Law on trademarks and trade names, now provided for in Articles 188, 189. 7. Act No. 899. Law regarding suspension on sentence, etc., upon U.S. citizens. 8. Act No. 1438, amended by Act Nos. 3203, 3309, and 3559, provisions governing juvenile offenders and delinquent children, their care and custody, now governed by Article 80. 9. Act No. 1508, Secs. 9, 10, 11, and 12. The chattel mortgage law, now penalized in Article 319. 10. Act No. 1523. Law prohibiting importation, sale etc., of lottery tickets and lottery, now penalized in Articles 195-196. 11. Act No. 1524. Section 4. Law governing discretion of Governor General in granting conditional pardons, now covered by Article 159. 12. Act No. 15533, Sections 1, 2, and 6 amended by Act No. 1559. Law providing for diminution of sentences by reason of good conduct and diligence, now governed by Article 97. 13. Act No. 1697, Sections 3 and 4. Act for the punishment of perjury in official investigations, now provided for in Articles 180-183. 14. Act No. 1754. Law on Counterfeiting and Forgery, now defined and penalized in Articles 160–169. 15. Act No. 1775. Act penalizing crimes against legislative bodies, now provided for in Articles 143–145. 16. Act No. 1757. Sections 1, 2, 3, 4, 5, 6, 7, First Clause, 11 and 12 amended by Act No. 3242. Act prohibiting gambling, now provided for in Articles 195–199. 17. Act No. 1173. Law on the crime of adulterio, estupro, rapto, violation, calumnia, injuria, etc., now governed by Articles 333–346. 18. Act No. 2071 and 2300. Act governing slavery, involuntary servitude, peonage, and the sale or purchase of human beings, now penalized in Articles 270–274. 19. Act No. 2212. Act providing for the confiscation and disposition of money, articles, instruments, appliances and devices in gambling, now provided for in Article 45. 20. Act No. 293. Act penalizing willful destruction, injury, or taking or carrying away any property of the Philippine Library, now provided for in Article 311. 21. Act No. 2364. Act penalizing infidelity in the custody of prisoners detained for or are convicted of a crime, now governed by Articles 223–225. 22. Act No. 2381. Secs. 2, 3, 4, 5, 6, 8, and 9. Act restricting the use of opium, etc., now provided for in Articles 190–194. 23. Act No. 2549. Act prohibiting the forcing, compelling, or obliging of any laborer or other employee to purchase merchandise, commodities, or personal property under certain conditions, and the payment of wages of a laborer or employee by means of tokens or objects other than legal tender currency, now penalized by Article 288, and also governed by Com. Act No. 303 and the Minimum Wage Law, Republic Act No. 602, as amended by Republic Act No. 812. 24. Act No. 2557. Act providing for the allowance to persons convicted of preventive imprisonment, etc., now embodied in Article 29. 25. Act No. 2595. Law fixing prescription of the crime of libel and of a civil action arising therefrom, now provided in Article 90. 26. Act No. 2711, Secs. 102, 2670, 2671, and 2672. Act amending the Revised Administrative Code. 27. Act No. 3104 amending Acts 2726. Law governing manner in which the death penalty shall be executed, now embodied in Articles 1885. 28. Act No. 3586 and 3397. Law governing habitual delinquency, now provided in Article 62, Par. 5. 29. General Orders No. 58, Series of 1900, Section 106. Code of Criminal Procedure. 30. Other laws repealed by the Revised Penal Code are Acts Nos. 2030, 2142, 2298, 2712, 3195, 3244, 3298, and 3313, which are merely amendatory laws on the old Penal Code. Presidential Decree No. 1602. Simplifying and providing stiffer penalties for violations of Philippine gambling laws. Whereas, Philippine gambling laws, particularly Articles 195-199, the Revised Penal Code, Republic Act No. 3063, Horse Racing Bookies, Presidential Decree No. 499, Cockfighting, Presidential Decree No. 483, Game Fixing, Presidential Decree No. 519, Slot Machines, and Presidential Decree No. 1036, JILI Bookies, and other city and municipal ordinances gambling all over the country have become ineffective and easily circumvented in view of the confusing and inappropriate system of penalties imposed on violations thereof. Whereas, there is an urgent need to update these gambling laws for simplicity and clearer understanding, and to standardize and provide stiffer penalties for their violations to make them more effective and responsive to the present norms of conduct and behavior of the people. Now, therefore, I, Ferdinand D. Marcos, President of the Philippines, by virtue of the powers vested in me by the Constitution and in order to effect the desired and necessary changes and reforms in the social and economic structure of our society, do hereby order and declare to be part of the laws of the land, the following. Section 1. Violations and Penalties. The penalty of prison may in its medium degree or a fine ranging from 500 pesos to 2,000 pesos, and in case of recidivism the penalty of prison correctional in its medium degree or a fine of ranging from 1,000 pesos to 6,000 pesos shall be imposed upon a. Any person other than those referred to in the succeeding subsection who in any manner shall directly or indirectly take part in any game of cockfighting, juteng, bookies, JILI or horse racing, to include game fixing, and other lotteries, Garawai Cruise or Pompiang and the like, blackjack, lucky nine, pusoy or Russian poker, monty, baccarat and other card games, polk K, domino, mahjong, high and low, slot machines, roulette, pinball and other mechanical inventories or devices, dog racing, boat racing, car racing and other races, basketball, volleyball, boxing, 7-11 dice games and the like, and other contests to include game fixing, point shaving and other machinations, banking or percentage game, or any other game or scheme, whether upon chance or skill, which do not have a franchise from the national government, wherein wagers consisting of money, articles of value of representative of value are made. b. Any person who shall knowingly permit any form of gambling referred to in the preceding subdivision to be carried on in inhabited or uninhabited places, or any building, vessel or other means of transportation owned or controlled by him. If the place where gambling is carried on has a reputation of a gambling place, or that prohibited gambling is frequently carried on therein, or the place is a public or government building or barangay hall, the culprit shall be punished by the penalty provided for in its maximum period and a fine of 6,000 pesos. The penalty of prison correctional in its maximum degree, and a fine of 6,000 pesos shall be imposed upon the maintainer, conductor of the above gambling schemes. The penalty of prison may in its medium degree and temporary absolute disqualification and a fine of 6,000 pesos shall be imposed if the maintainer, conductor or banker is a government official, or if a player, promoter, referee, umpire, judge or coach in cases of game fixing, point shaving and other game machination. The penalty of prison correctional in its medium degree and a fine ranging from 500 pesos to 2,000 pesos shall be imposed upon any person who shall knowingly and without lawful purpose in any hour of any day shall have in his possession any lottery list, paper, or other matter containing letter, figures, signs or symbols which pertain to or in any manner used in the game of juteng, JILI or horse racing bookies and similar game or lottery which has taken place or about to take place. Section 2. Barangay Official. Any barangay official in whose jurisdiction such gambling house is found and which house has the reputation of a gambling place shall suffer the penalty of prison correctional in its medium period and a fine ranging from 500 to 2,000 pesos and temporary absolute disqualifications. Section 3. Informer's reward. Any person who shall give the information that will lead to the arrest and final conviction of the offender shall be rewarded an amount equivalent to 20% of the cash money confiscated from the offender. Section 4. Repealing clause. The provisions of Articles 196, 197, 198 and 199 of the Revised Penal Code, as amended, Republic Act No. 3063, Presidential Decree Nos. 483, 499, 510, 1306, Letter of Instructions, Laws, Executive Orders, Rules and Regulations, City and Municipal Ordinances which are inconsistent with this decree are hereby repealed or accordingly modified. Section 5. Effectivity. This decree shall take effect immediately upon publication thereof by the Minister of the Ministry of Public Information at least once in a newspaper of general circulation. Done in the city of Manila, this 11th day of June in the year of our Lord, 1978. _ Presidential Decree No. 1613. Amending the law on arson. Whereas, findings of the police and intelligence agencies of the government reveal that fires and other crimes involving destruction in Metro Manila and other urban centers in the country are being perpetuated by criminal syndicates, some of which have foreign connections. Whereas, the current law on arson suffer from certain inadequacies that impede the successful enforcement and prosecution of arsonists. Whereas, it is imperative that the high incidence of fires and other crimes involving destruction be prevented to protect the national economy and preserve the social, economic and political stability of the country. Now, therefore, I, Ferdinand D. Marcos, President of the Philippines, by virtue of the powers vested in me by the Constitution do hereby order and decree as part of the law of the land, the following. Section 1. Arson. Any person who burns or sets fire to the property of another shall be punished by prison mayor. The same penalty shall be imposed when a person sets fire to his own property under circumstances which expose to danger the life or property of another. Section 2. Destructive arson. The penalty of reclusion temporal in its maximum period to reclusion perpetua shall be imposed if the property burned is any of the following. 1. Any ammunition factory and other establishment where explosives, inflammable or combustible materials are stored. 2. Any archive, museum, whether public or private, or any edifice devoted to culture, education or social services. 3. Any church or place or worship or other building where people usually assemble. 4. Any train, airplane or any aircraft, vessel or watercraft, or conveyance for transportation of persons or property. 5. Any building where evidence is kept for use in any legislative, judicial, administrative or other official proceedings. 6. Any hospital, hotel, dormitory, lodging house, housing tenement, shopping center, public or private market, theater or movie house or any similar place or building. 7. Any building, whether used as dwelling or not, situated in a populated or congested area. Section 3. Other cases of arson. The penalty of reclusion temporal to reclusion perpetua shall be imposed if the property burned is any of the following. 1. Any building used as offices of the government or any of its agencies. 2. Any uninhabited house or dwelling. 3. Any industrial establishment, shipyard, oil well or mine shaft, platform or tunnel. 4. Any plantation, farm, pasture land, growing crop, grain field, orchard, bamboo grove or forest. 5. Any rice mill, cane mill or mill central, and 6. Any railway or bus station, airport, wharf or warehouse. Section 4. Special aggravating circumstances in arson. The penalty in any case of arson shall be imposed in its maximum period. 1. If committed with intent to gain. 2. If committed for the benefit of another. 3. If the offender is motivated by spite or hatred towards the owner or occupant of the property burned. 4. If committed by a syndicate. The offense is committed by a syndicate if it is planned or carried out by a group of three or more persons. Section 5. Where death results from arson. If by reason of or on the occasion of arson death results, the penalty of reclusion perpetua to death shall be imposed. Section 6. Prima facie evidence of arson. Any of the following circumstances shall constitute prima facie evidence of arson. 1. If the fire started simultaneously in more than one part of the building or establishment. 2. If substantial amount of flammable substances or materials are stored within the building not necessary in the business of the offender nor for household use. 3. Gasoline, kerosene, petroleum or other flammable or combustible substances or materials soaked therewith or containers thereof, or any mechanical, electrical, chemical, or electronic contrivance designed to start a fire, or ashes or traces of any of the foregoing are found in the ruins or premises of the burned building or property. 4. If the building or property is insured for substantially more than its actual value at the time of the issuance of the policy. 5. If during the lifetime of the corresponding fire insurance policy more than 2 fires have occurred in the same or other premises owned or under the control of the offender and or insured. 6. If shortly before the fire a substantial portion of the effects insured and stored in building or property had been withdrawn from the premises except in the ordinary course of business. 7. If a demand for money or other valuable consideration was made before the fire in exchange for the desistance of the offender or for the safety of other person or property of the victim. Section 7. Conspiracy to commit arson. Conspiracy to commit arson shall be punished by prison in its minimum period. Section 8. Confiscation of object of arson. The building which is the object of arson including the land on which it is situated shall be confiscated and escheated to the state, unless the owner thereof can prove that he has no participation in nor knowledge of such arson despite the exercise of due diligence on his part. Section 9. Repealing clause. The provisions of Articles 320 to 326b of the Revised Penal Code and all laws, executive orders, rules and regulations, or parts thereof, inconsistent with the provisions of this decree are hereby repealed or amended accordingly. Section 10. Effectivity. This decree shall take effect immediately upon publication thereof at least once in a newspaper of general circulation. Done in the city of Manila this 7th day of March 1979. Presidential Decree No. 1744. Amending Article 320 of the Revised Penal Code provisions on arson. Whereas, there have been rampant and wanton burnings of residential houses, public buildings, markets, hotels and other commercial establishments. Whereas, to effectively discourage and deter the commission of arson, and to prevent destruction of properties and protect the lives of innocent people, it is necessary that the capital punishment be imposed upon arsonists. Now, therefore, I, Ferdinand D. Marcos, President of the Philippines by virtue of the power vested in me by the Constitution, do hereby order and decree that Article 320, Revised Penal Code be amended. Section 1. Article 320 of the Revised Penal Code shall read as follows. Article 320. Destructive arson. The penalty of reclusion temporal in its maximum period to death shall be imposed upon any person who shall burn 1. One or more buildings or edifices, consequent to one single act of burning or as a result of simultaneous burnings, or committed on several or different occasions. 2. Any building of public or private ownership, devoted to the public in general or where people usually gather or congregate for a definite purpose such as but not limited to official governmental function or business, private transaction, commerce, trade workshop, meetings and conferences, or merely incidental to a definite purpose such as but not limited to hotels, motels, transient dwellings, public conveyance or stops or terminals, regardless of whether the offender had knowledge that there are persons in said building or edifice at the time it is set on fire, and regardless also of whether the building is actually inhabited or not. 3. Any train or locomotive, ship or vessel, airship or airplane, devoted to transportation or conveyance, or for public use, entertainment or leisure. 4. Any building, factory, warehouse installation and any appurtenances thereto, which are devoted to the service of public utilities. 5. Any building the burning of which is for the purpose of concealing or destroying evidence of another violation of law, or for the purpose of concealing bankruptcy or defrauding creditors or to collect from insurance. Irrespective of the application of the above enumerated qualifying circumstances, the penalty of death shall likewise be imposed when the arson is perpetrated or committed by two or more persons or by a group of persons, regardless of whether their purpose is merely to burn or destroy the building or the burning merely constitutes an overt act in the commission or another violation of law. The penalty of reclusion temporal in its maximum period to death shall also be imposed upon any person who shall burn. 1. Any arsenal, shipyard, storehouse or military powder or fireworks factory, ordnance, storehouse, archives or general museum of the government. 2. In an inhabited place, any storehouse or factory of inflammable or explosive materials. If as a consequence of his commission of any of the acts penalized under this article, death or injury results, or any valuable documents, equipment, machineries, apparatus, or other valuable properties were burned or destroyed, the mandatory penalty of death shall be imposed. Section 2. Provisions of Articles 320, 321 and 322 of the Revised Penal Code which are or may be inconsistent herewith are hereby repealed. Section 3. Effectivity. This decree shall take effect immediately. Done in the city of Manila, this 11th day of November, in the year of our Lord, 1980. The other provisions of Republic Act 4363, approved 1965 are as follows. Section 2. If any section or sections of this act shall be declared unconstitutional or invalid, it shall not invalidate the other sections hereof. Section 3. This act shall take effect only if and when, within 30 days from its approval, the newspapermen in the Philippines shall organize and elect the members of a Philippine Press Council, a private agency of the said newspapermen, whose function shall be to promulgate a code of ethics for them and the Philippines press, investigate violations thereof, and censure any newspaperman or newspaper guilty of any violation of the said code. And the fact that such Philippine Press Council has been organized and its members have been duly elected in accordance herewith shall be ascertained and proclaimed by the President of the Philippines.